Fourth Amendment rights in two ways when they stopped him and searched him during a shopping trip at the car stereo warehouse. First, they seized him without probable cause or reasonable suspicion. And second, Officer Schur exceeded the permissible scope of a Terry search for weapons when he searched Drakeford's pocket for drugs. The Supreme Court's decision in Glover and this court's decision in Brinkley make clear that police cannot ignore facts that dispel probable cause or reasonable suspicion. But here they did exactly that. Interpreting Drakeford's second handshake in front of the car stereo warehouse as a drug transaction ignores numerous facts that made the officer's suspicions about the handshake unreasonable. And no court has found even reasonable suspicion based on similar facts. First, consider the custom of shaking hands. Detective Murphy repeatedly testified that his only reason for thinking the handshake was suspicious was that it was a second handshake and was longer than the first. But handshakes are ubiquitous and can mean many different things.
Excuse me, Ms. Hester, but
Yes.
wasn't there more knowledge that the officers had before getting to that second handshake, information from the informant that I guess they said this informant had been credible in the past?
Right. So let's talk about the informant, because the police were relying on an informant whose allegations of drug dealing had never predicted any of Drakeford's movements and had repeatedly failed to bear fruit during the officer's surveillance. After receiving that initial tip, once they finally figured out where Drakeford actually lived, officers watched Drakeford more than 30 times over the course of a month or more before they saw anything that even they thought was suspicious. And what's more, all their attempts to corroborate the informant's general allegations of drug dealing had turned up empty. So the first time they thought they saw something was suspicious was on Thursday, February 1st, where they saw Mr. Drakeford meet in a gas station parking lot with the man in the white pickup truck. So they followed that truck and had other police officers search it, but that search came up empty. They didn't find any drugs. All they found were some syringes. Later that same week, which would have been February 2nd, 3rd, or 4th, they watched him drive to a gas station and park, but he didn't meet anyone. So that same day, they called the informant and asked the informant to make contact with him. She did. He said she reported he said that he didn't have any drugs. Then they watched him drive to a house, pick up a bag, and then the informant told him while Drakeford was driving home that he told her he had drugs to sell. But still, even after that event, for 5 days or a week after that, the officers didn't observe Drakeford engage in any conduct that they thought was a drug transaction. And perhaps most importantly, the informant never predicted any of Drakeford's movements or even told police that Drakeford was engaged in a drug transaction at a specific time and place. So even
I just want to clarify. It wasn't the informant didn't tell them that he was going to be at this stereo warehouse that afternoon either, did?
No,
did
the
he
informant,
or
she never predicted any of Drakeford's movements that day or any
And they
other.
never did any controlled buys or attempted any controlled buys
That's
with
correct.
this informant or
That's
anybody
correct. Or anybody
with this defendant.
That's correct. That's correct. And even aside from the weaknesses in the informant's information, there are other things besides. There's the custom of shaking hands, which, as this court well knows, does not always happen at the beginning of a conversation. It can also be used to shake hands to offer congratulations or express gratitude or at the end of a conversation.
Well, of course, we are familiar with the handshakes.
Yes.
At least in the old days. But let me ask you, do you agree that in the aggregate, even otherwise innocent conduct can give rise to a reasonable suspicion?
I think that that's true, but I think it is true when you have an informant who is predicting movements, that otherwise innocent movements that corroborate an informant's predictions of what the defendant is going to do can establish reasonable suspicion. But that we don't have that here.
But this informant is just a single piece of this puzzle. If she was the only evidence, only source, then perhaps it sounds like to me it'd be stronger. But there's more here than just an informant.
Well, what they have besides the informant is a handshake where the officer who said that he observed that admitted that he never saw any suspicion it up against the body of the defendant in order to feel what's underneath. So this court has found the district court's factual finding clearly erroneous when it conflicts with objective evidence such as a video recording. So here, after reviewing the video evidence, the court should be left with the definite and firm conviction that the district court's factual finding is wrong, and that Scher squeezed or manipulated Drakeford's clothing before reaching into his pocket, which violated Drakeford's rights under the Fourth Amendment, under Terry and Sabron, because he manipulated Drakeford's pocket during a search that he admitted was at least in part a search for drugs. In conclusion, police violated Drakeford's Fourth Amendment rights in two different ways when they stopped him and searched his pocket, but either one of those violations alone is enough to require suppression. Thank you.
Thank you, Ms. Hester. Ms. Ray?
May it please the court, Amy Ray for the United States. Your Honors, this court should affirm the judgment of the district court because the district court properly held that reasonable suspicion supported the pat down of Mr. Drakeford, and the court credited the officer's testimony. Nothing in the video can overcome or does overcome the officer's testimony, two of whom said that Officer Scher conducted a proper pat down and did not manipulate the pocket.
But Ms. Ray, before we get to the pat down of the pocket, doesn't there have to be reasonable suspicion in the first instance to stop the appellant?
Absolutely. And Your Honor, we had more than
that.
I'm sorry, I didn't mean to interrupt you.
What's your best evidence of reasonable suspicion in the first instance?
So the best evidence is the aggregate evidence of, first of all, Detective Murphy, who had both seen and conducted hand-to-hand transactions, said that he witnessed a hand-to-hand transaction. And the other pieces.
Excuse me, Mr. Ray, that's a conclusion. What he said was he didn't see any drugs, and he saw two people shake hands. You can be an expert all you want, but that doesn't make you have a conclusion that you saw anything. What you're saying is that, and this case is just amazing. What you're saying that if we believe you're a drug dealer, that means if you shake hands with anybody, you could say, well, I believe he's a drug dealer and he shook hands, and I've seen him shake hands before, have other people shake hands, and it's a drug dealer. That can't be the law.
It's not the law.
It's not the, but what didn't you just say that he's seen handshakes before? He didn't see any drugs. He saw a handshake.
Your Honor, he saw two handshakes. The first handshake he did not think was a hand-to-hand transaction.
Okay, the second one, no, wait a minute. Did he see drugs the second time?
No, but this court has upheld reasonable suspicion based on hand-to-hand transactions where the officer did not see drugs.
And that's all. Wait a minute. In those cases where, and that was the case, that's all they saw in those cases?
There was no more information, for example, in United States versus Linder, than where they saw people looking in an open palm of a hand and did not see anything more than that. And the court said, yes, based on it was dark, it was late, they were suspicious of these folks. The point is that in addition to this hand-to-hand, we also had evidence not only from an informant who had not provided information in more than 50 investigations, a number of which over 10 years, a number of which had yielded convictions and helpful assistance, but also an informant who had recently confirmed that Mr. Drakeford had received a resupply of drugs, heroin specifically.
When you say recently confirmed that he'd received a resupply of drugs, how recently? The brief says the same day, but the record doesn't seem to bear that out.
Your Honor, I agree, and that was my mistake. I would say it was within a few days. It was no more than 5. And I looked back to see what I was relying on, and it was some cross-examination of Officer Moore, Detective Moore. But in any event, it was within 4 or 5 days at the most.
There was no controlled buy. once the informant?
No, but I would respectfully say, let's bear in mind that reasonable suspicion is well less than a preponderance of the evidence, right? It's more than a hunch, but it's much less than a preponderance of the evidence. So we have a gentleman who, a known and reliable informant, has said he is trafficking heroin and cocaine. That informant, that's not the only information that she gave.
Didn't say, I'm sorry, but the informant didn't say that this defendant was trafficking in cocaine, because she didn't provide a name or an address, only a license number and a general description that could apply to a lot of people, correct?
Well, it was a general description, but it happened to meet the description. It was a light-skinned black man, heavy set, with a beard, and that matched Drakeford's physical description, and the license plate came back to Mr. Drakeford.
You said Mr. Drakeford is a light-skinned black person?
It's light. He's lighter skinned than I wouldn't characterize him, Judge Gregory, as dark skinned. And
I've seen the video, and
I have also.
And so we deal with people who say that's consistent to say he was a light skinned black person. Him,
Your Honor.
That turns on his head. That alone is the problem there. You're telling us that it was consistent because she said a light skinned black person he was, and you said that's consistent. I've seen the video.
Fair enough, Your Honor.
Not.
Your Honor, she said he was heavy set, he had a beard, he's a black man, and they traced the car's license plate back to Mr. Drakeford. They then watched Mr. Drakeford, and they saw him engage in what appeared to be a possible drug trafficking transaction in a parking lot of a gas station. They followed
what appeared to possibly be.
Right, and this is sure, and they didn't arrest him.
So that means that, So he's a black person in a car. He's talking to somebody, so that means it appears he possibly was drugs. Is that what you just said?
He engaged in activity that they believed was consistent with drug trafficking. They followed the truck.
What is the activity? What is the activity?
They saw him go into the parking lot of a QT gas station and sit there and wait. And then when a car arrived, the gentleman in the truck, white truck from the South Carolina license plates, got into Mr. Drakeford's car. 45 seconds later, approximately, he gets back into his truck. The officers follow him. And because he's slowing down and speeding up and slowing down and speeding up, they're concerned that he's getting high. So they have a Rock Hill, South Carolina officers pull him over. A drug dog alerts to the truck for narcotics. Now, they did not find narcotics, but they found syringes. And so it is quite possible that he had engaged in a drug trafficking transaction, and at a minimum, or a deal, some conversation about a future deal. The point is that it was behavior that's consistent with what the experienced officers.
Right. The experienced officer said that the handshake was a drug transaction in his experience. Didn't the officer also testify, as you're arguing, that drug transactions typically take place by one person getting into another vehicle and the transaction takes place there, which is what they thought happened, but apparently did not happen with the white truck? There was no, they didn't, on the day that they stopped him and arrested him, nobody got into the vehicle. They were in broad daylight in the afternoon in an area that was not high crime, in front of a security camera, in front of a business, shaking hands, and then they went into the business instead of getting into the car and driving away with what purportedly was drugs. That just seems like normal activity, particularly in light of the fact that they had not, none of the times they tried to catch him before for fruit. And we can't ignore those facts.
Your Honor, a couple of things I would respond. First of all, I don't think that the interaction with the truck necessarily did not bear fruit. The drug dog can't alerted for the presence of narcotics. But let's turn to the car stereo warehouse. It's important to remember, one, Detective Moore did not testify that that's the only way drug transactions happen in the city of Charlotte. And we know from the videotape and from the testimony that Mr. Drakeford knew the owners of the car stereo warehouse. He was well familiar with him. In fact, he left his keys with them when he left. So this was a place that he knew the owners. He was known there, and he was comfortable there. And because there were two handshakes, and the second one appeared to be a handshake conducted in a particular manner, not just any handshake, a longer, more deliberate handshake, that experienced officer testified, I've done that before. I've seen that before many times. And I believe that that was a hand-to-hand transaction. And when we combine that with the other evidence that they had garnered over the time, that he had been recently resupplied, whether it's 3 days, 5 days, or the same day, he had.
I've seen long handshakes too in public places that are not drug transactions.
No doubt.
I understand about the totality of the circumstances. But
Your Honor, I'm sorry.
When I asked you, I know, I'm sorry. When I asked you about your best evidence of reasonable suspicion in this totality of the circumstances, I think you said it was the handshake, right? The second handshake.
Let me just make clear. It is everything combined. We can't, the best evidence is the handshake plus the informant's information plus watching him conduct.
Let me ask the question in a different way to you. When do you say that the officers develop reasonable suspicion?
Yeah.
By the time that they, there's, let me just say this, to support this particular pat down, they developed reasonable suspicion at the time of the hand-to-hand transaction.
So the hand-to-hand transaction occurred, and then was that at the stereo store?
Yes, sir. Yes.
So you got the Supreme Court case of Kansas versus Glover. You're familiar with that.
Yes.
And that's a case that said you can have these facts, but if you have additional facts, it can dispel the reasonable suspicion. So when we look at what happened after this, and they just casually walk into this stereo store, that's not consistent with someone. I mean, I'm not being argumentative. I think you frown a bit, but follow me on this.
Sure.
You don't conduct a drug transaction out in the open and then just casually walk in a carefree manner into a store.
Judge Wynn.
I mean, I don't know any officer who testified to that. I don't know. Maybe our own experiences. I'm talking about what the record reflect. Nothing shows. In fact, it shows that that's rather incredulous that they would conduct this drug thing and then walk in casually in the store and for everybody, drugs and all of that. So why is that not at least something that might give us some pause on the Kansas versus Glover? The case
Your Honor,
came out last year.
For a couple of reasons. First of all, it's a hand-to-hand transaction. It's something that is small enough.
Well,
to be
you
put
call it
inside
a hand-to-hand transaction because as Chief Judge has indicated, you've reached that conclusion based upon what you did.
Yeah,
there was no drugs.
Enough.
There was no drug scene. What you have is a handshake, which yes, could lead to the conclusions. My statement is, if that's all happens to get in the car, you have a stronger case. I'm not saying you don't have a case, but if you shake a hand, walk in. What if you go in and watch a movie, or you just go in and sit down and have dinner after you have this so-called hand-to-hand transaction under the Kansas versus Glover is what I'm saying. I'm not saying that's innocent to walk into the store. I'm only saying Kansas versus Glover says if there's some additional facts that could dispel this so-called reasonable suspicion that we would ordinarily give to someone who has experience of a handshake. So, oh, that's a handshake. But it would seem to me, once you do this additional thing, you need something a little bit more than they shook hands. And by the way, how did they shake hands? Can you describe it again? I'm trying to understand.
Hey.
I kind of have an understanding of how, in the normal circumstances, maybe men like this would shake hands. How did they shake hands?
Your Honor, I want to respond. I will respond to
answer
that.
that. I want to hear that, but I want to hear that right now. I want to hear that now.
I will answer that question. I'd also like to respond to
No,
your question
but
about Glover.
I'm going to let you do that.
The answer to your
hold on a minute. Let's make sure we're on the same page.
Sure.
Because I like to I get confused easily in these things here. So when I say how was, because you rely on this handshake a lot, how was the handshake conducted?
It was a long and deliberate handshake.
What does that mean? What do you mean? Was it done in the regular way of a handshake, or was it the fingers in a certain way, or was it a dap, so to speak? How was it done? Long?
It was distinguished from a dap. It was a longer handshake. All I can tell you is what the record reflects.
No, well, that's all I'm asking you. Let's make sure. Hold on a minute. If you can avoid the extraneous conversation and give me the facts of the handshake, I want to move from this. I'm not trying to trick you up. I'm just asking. That's all. I'm just trying to find that fact out. That's all.
Understood.
So tell me, how did the handshake occur? Describe it.
The handshake was long and it was deliberate, and it was the second handshake that they had engaged in.
Okay.
We
understand what a handshake is, but describe what the handshake is in this instance. In other words, to use the term handshake, I'm going to have to assume I know what a handshake is. I'm asking you to describe it because you rely on it tremendously. And it shouldn't be difficult to tell me. They took their fingers, they wrapped it around the palm of their hands, or they did something of that nature. That has to be something you know.
Your Honor, the record reflects three things. First, that it was longer and more deliberate than the initial handshake. Second, that it occurred right after that handshake. And third, that an experienced officer interpreted it to be a hand-to-hand. We don't have more than that.
Let me make sure I understand how you answered my question. I understand what the record reflects, but do you understand? You just said to me, handshake, handshake, handshake. I asked you, what is the handshake? Does that make any sense? I know the record reflects a long handshake. It reflects this. What was the handshake? Describe the handshake. How did it happen? I cannot
tell you more than what the record says, and it says it was
longer.
No,
if you cannot do that, then just say, I don't know. That's all I want to know. Because I know what the record says. Just say, I don't know. And they don't, and the record doesn't tell us. Say the record doesn't tell us or describe the handshake.
Your Honor, I believe I said that. I believe what I said is what we know from the record is that it was a longer and more deliberate handshake than the first.
You are not answering my question, and I don't want to be argumentative on it, but I'm going to get this point. I'm going to make sure we are together on this point. So I want you to listen to me carefully. I'm not asking you about what the record says in terms of the use of the word handshake. I'm asking you, and it's either yes or no, does the record describe the nature of what constituted a handshake?
No, not beyond what I've described. And I'm sorry.
I don't need the extra. All I needed was no. Mm-hmm. You don't have to explain it. I can figure out you didn't do it beyond what you described. Just say, no, it doesn't do it. And that doesn't mean anything. It just says, no, it didn't describe the handshake. That's all. Other than what the officer concluded that it was the type of handshake that he was familiar with that would indicate this. I got that. But to tell us, but we don't have information of how this handshake was done. If it's an important handshake, this is one of the great handshakes. This handshake to send this guy away for years, which that may be well and good. But I just wanted to know, it would seem to me that even in the course of a trial, if someone relied heavily on a handshake, they would describe the handshake. They may even have them come up and describe to the jury what the handshake looked like, and then give a statement of this is how they did it and this is what happened. Because this officer, with all of his vast experience, he's seen drug to drug transaction, but you know what? We've seen people exchange stuff secretly in hands too. Doesn't have to be drugs. You can exchange something secret you don't want someone to see. That's the same kind of knowledge here. There's nothing special about the drugs except you don't want someone to see it. And that might give him some specialized knowledge. Okay, I've seen it with drugs. But any one of us, any layman out there can probably testify, you too, you've seen people exchange stuff in a handshake. You may have done it yourself, where you weren't trying to show what you were actually exchanging. I've done it. I mean, I've given money to people, my family members, and I didn't want everybody to see it. So I took the money and put it in the palm of my hand, and it wasn't a long one, but it was enough for them to know, and they received it. So that's what we have here, seems to me, as the primary evidence. And I only asked, what was described, the handshake itself? Your answer is the record doesn't reflect that.
Thank you. If I may,
don't thank me. I won't. Wait a minute. I don't want to thank you. I want you to move forward. But I don't want this. I don't want a thank you for
Judge
something.
Wynn, I would love to move forward.
Okay.
So
if you can be quiet, I'm going to let you move forward. But understand what I'm saying, because I want our answers. What I want you to understand is that when I'm asking, are we okay? I'm not beating up on you. I hope I'm not beating up on you at all. What I'm
good, Judge Wynn.
Okay, good.
I'm just
good.
waiting to be able to respond to your Glover
You will
question.
be able to respond, but you will not stop talking. You will, and all I'm saying is, I asked a very simple question. Don't anticipate where I'm going. I wasn't against you on that question. I was simply asking, how was the handshake done? And all I kept getting was a circular answer of what the officer knew and all of that. So that's where we are. And when we get to the word no, then no, let's proceed. But we don't need extra conversation. Thank you and all of this other stuff. You see what I'm saying? So let's go forward. Go forward. Just go forward. Just go forward.
Okay, thank you. So I'd like to respond to, and I see that my time is up, so if I may.
Yeah, you may. You may.
Thank you, Your Honor. I'd like to say that we're not relying only on the handshake, and there's, I think our brief sets out the other evidence that we are relying upon. To respond to Your Honor's question about Glover and the fact that these gentlemen walked into the car stereo warehouse, I would respectfully suggest that if they conducted a hand-to-hand transaction, and I note that Mr. Anthony, they found a small amount of narcotics in his pocket. That's reflected on the video. So if they knew each other and all they did was get a little bit, something very small, he puts it in his pocket. There's nothing inconsistent with going into a store where they know the owners, where they're friendly, and spending a few minutes in the store. That, in my opinion, in my judgment, and I think it's fair for the district court to judge, that would not take away at all. I live in an urban neighborhood, actually in Asheville, the only maybe urban neighborhood in Asheville. It wouldn't surprise me at all for a hand-to-hand transaction to occur and for the gentleman to walk into the corner store right near where the transaction occurred, across the street from my house. So I'm not saying that it couldn't happen. I just don't think it detracts from the value of an experienced officer who testified. I have done these. I have witnessed them. This court has considered, as have other circuit courts. Oh, Judge Thacker, I'm sorry, I didn't see you.
Chief Judge Gregory, can I have one question? I know her time is.
Absolutely.
All right.
My apologies for taking up so much of your time on this right here. And I didn't mean to do that. It just seemed to have gone that way. And Ms. Ray, I did not mean to throw you off on it, but I wanted to get a direct answer. And it was being very difficult, maybe because of our skill in knowing that we work with each other many times on these things. So, but please.
If I may, I would like to at least say that I was actually trying to answer your question, to say that.
Well, I believe you were. I think you were trying. It just you may not have understood my question correctly, and that's why it took me such a time to be able to articulate my question. I'm not sure you understand it right now, but I'm clear with the answer, though.
Yeah. All right. So, Ms. Ray, opposing counsel said that the government has cited to no case in any court with similar facts to this one, and also that our Foster case is applicable and goes against the government. So what is your best case to support reasonable suspicion here?
I think that Linder is a good example of a case, and I've cited that in my brief. It was a published decision by this court in 1993. And what happened in that case was that they saw a group of men in a fast food parking lot in a dark area. All they could see was that they were looking into an open palm. And that was enough to support reasonable suspicion. Now, I might have looked at that and thought they could have been looking at an interesting insect. Who knows? But this court found that that was enough to support the district court's finding of reasonable suspicion. And the thing about Foster is, and the reason that Foster is not particularly helpful, I think, to Mr. Drakeford, is that in Foster, they didn't see any kind of transaction that the officers recognized as a hand-to-hand transaction or something that looked like drug trafficking. All they saw was movement of an arm above an elbow, and somebody had been the passenger of the car wasn't immediately visible. They also weren't aware exactly of the fact that of what Mr. Foster's criminal history was here. In this case, Detective Moore was well aware that Mr. Drakeford had both been arrested and had been convicted of drug-related offenses, a number of them, not just one or two. We didn't have that information in Foster. We also in Foster didn't have an informant that had told us that Mr. Foster had been engaged in drug trafficking. We hadn't followed up with surveillance that showed him engaging in behavior consistent with drug trafficking. We didn't know that he had just visited a home and gotten resupplied with heroin. So all of those facts that are present in this case distinguish this case from Foster and make it stronger than Foster. And in fact, I would argue, make it much stronger than Linder.
Ms. Ray, but the problem is that what you said was part of your panoply of pre-knowledge in the truck situation. You didn't see any hand-to-hand contact in the truck, did you?
Your Honor, it happened in a car, so no, Your Honor.
Well, I don't mean about a truck, but in a car, did you? Same thing with Foster, why is that different? That means that shouldn't count then, right?
No, that fact, I'm sorry, Your Honor, that fact is the same. So it's true that both in Foster and in this case, leading up to it, they didn't see the drugs, or even in this case during the hand-to-hand, they didn't see the money or the drugs. But that's true in a lot of hand-to-hand transactions. You have an
informant who hasn't proven to be reliable about anything. Because you didn't find any drugs at all. You didn't find any drugs.
We found drugs after we patted Mr. Drakeford down.
No. I'm not talking about this. I'm talking about prior. You judge the informant prior, not after, because otherwise it's self-fulfilling prophecy. They were right, you see. You can't backtrack that. She hadn't given you anything that panned out.
Well, Your Honor, with all due respect, she gave us the identity of Mr. Drakeford, and then we followed him and saw him engage in activity that appeared consistent with drug trafficking, including going into a gas station and sitting there and waiting, and nobody arrives, and so he leaves. And so they see conduct that is consistent. They see him go into a house with nothing, with a car with Florida plates, and come back out about a half hour, 45 minutes later carrying a bag. And then on that very same trot, before the officers even got back to the station house or wherever they were going after surveillance, the informant calls and says, "Hey, Drakeford just called me and he's been resupplied." So that is corroboration. That is corroboration.
What it is that that's innocent conduct that once you decide someone you believe is a drug dealer, then everything they do, you would say he used a payphone and called somebody up. That's consistent, wouldn't you?
Only if experienced officers testified that using a payphone at a particular time and in a particular way was consistent with drug trafficking. You have to have the officers say, this is consistent.
Well, this is consistent. Well, for example, the problem is that when you talk about that, you can so easily target neighborhoods. You know, good and well.
Sure.
With officers, they can say, I'm in this public housing section. It's consistent with my experience that people sell drugs here. Do you think that happens?
Absolutely. And this.
All right. Do you think that people in those areas shake hands with each other?
Sure.
All right. Then that would mean that if someone told you that, you stand in the area, they're shaking hands, therefore, that's probable cause that they're drugs, even though I don't see them because they normally shake hands when they do drugs, right? Wouldn't that be the connection you have?
No, Your Honor. You'd have to have a lot more than that.
Oh, really? You have
Yes.
an expert, you have somebody who's an informant who hasn't panned. The only thing you said it panned out to is that the behavior is consistent with drugs, which is sitting in a parking lot. Well, I go to the grocery store all the time. I can't recall an occasion where I don't see people sitting in the car and don't immediately get out. I see people get in the car sometimes. If you are of the mind that I'm in a place with drugs, that's consistent. But if you're at a place where you in your suburban neighborhood, not you personally, then then that's okay. They were in to meet someone, or that's just their friend. They're just talking. What neighborhood you're in? We had a case that came out of Richmond, and Fourth Circuit had that in a sense. But no mind. But go ahead. I see where you're following.
Your Honor, I think, right. I mean, I think that the distinction is that, number one, we're not asking this court to find reasonable suspicion based only on the hand-to-hand. It includes the other behavior, which includes a short transaction in a gas station parking lot with a gentleman who drove off, had syringes in a car, and the current canine alerted to it, and they were concerned that he had gotten high along the way. We have much more than simply the hand-to-hand. But it is important that this court has upheld probable reasonable suspicion. And I just have to, the last thing I want to say is to remind the court what you already know, but I'm going to have to say it, which is reasonable suspicion does not require that it be more likely than not that that handshake was a hand-to-hand. It doesn't have to have been more likely than not true.
So then that allows you then with the handshake to go to his car, make him get out of his car, put him back, take him from there, which is required to do, put his hands on the back, and then go into his pocket.
Well, if you pat him down and you feel what you know immediately is narcotics, after you have not only the hand-to-hand that you believe you've seen, having conducted them, but all of the rest of the information that they had.
Well, you can see that he went into his pocket, don't you, before the pat down, don't you?
No, sir, absolutely not.
I've seen the video. You can see him manipulating the pocket. Before the
Your Honor,
because the officer says I've seen the video a couple of times. After he puts him in handcuffs, the officer said, "Should we do the pat down now?" He says, "Yes." He's already been in his pockets.
Your Honor, the officer said, I asked him that question because to finish the pat down. When you see the zipper fly up, he has touched on the outside, and that's what he testified to.
That's what I mean. He touched the outside, but that was not a pat down, was it? He wasn't patting down because that was a loose hanging place. If you had a weapon in there, my goodness, it would have weighted it down. It was a lightweight thing that was open. It wasn't even zipped, was it?
It was not zipped, and in the process of touching his outside of his pocket, he didn't have a weapon, as it turned out. But in the process of touching the pocket on the outside, they both testified that he conducted a brief pat down of the pocket, and he testified he was more than 90% sure that it was narcotics when he touched it. The real question is whether the video can overcome the district court's credibility determination that officers, Detectives Sir and Hepner, were telling the truth when they said that he touched him first before he pulled out and that he conducted a proper pat down. And I don't believe that there's anything that you can see in that video that would say that those officers were lying about that.
Nobody says you don't have to show that he's lying. The point is show that he's touched. You can see him touching the pocket. And it is correct. And is it not a type where you're spanking type touching, correct? You know what I mean?
Right. Now
it's not, is it?
No, I mean it's an unzipped, very loose jacket, which you can see obviously it's obvious on the video. But he had to touch it, and if you're going to touch a jacket that loose, it's likely that it's going to move. Also, he may have gone under and searched for weapons at the waistband. I don't know, which would have caused that to lift up. The point is that they both testified that he did not manipulate the pocket, that he did not go into it until after he conducted a brief pat down of the outside of that pocket, which they were concerned about because he kind of continually put his hand in that pocket or over that area. And there's nothing in that video that I would respectfully suggest could cause this court to hold that the district court's credibility finding was clearly erroneous.
Well, the point is you don't need to get that far if you don't have reasonable suspicion anyway.
Without question, that's correct. Okay. If this court holds there's no reasonable suspicion.
I want to ask one question I'm curious about, and that is, if this officer was on his first day of job, he had none of this experience, would this case go the other way?
That would be up to the district court as to whether or not to credit it. I don't know, but
the reason I bring it up is because there's so much testimony on the experience of the officer, particularly with the handshake. If the officer does not have that experience, then it's just a handshake. right?
I think that, I think that's probably true, Your Honor. I think
So
if
an
the officer
officer
had
who
not,
was on his first day, so it really depends of evidence in a case depends on the experience of an officer and the testimony that they understand. They actually become experts, I suppose, to some
that's
degree.
exactly what the Supreme Court has recognized.
I
Yes.
understand what the Supreme Court has recognized, but I want to get to the truth of the matter, because what the Supreme Court often recognizes in a case like this, you only need to say you did it or that you have the experience and you know it. And even though I don't think the Supreme Court has ever said seeing alone makes anybody an expert, you can't get up and say I'm a chemist and you don't really have that background. But it's an interesting, I was just curious as to, does this case depend on the fact that these officers were so-called more experienced and had this experience as opposed to an officer who did not have it? And it seems to me it does turn very strongly on that.
I think that's a powerful part of our evidence.
Okay, thank you. That's helpful.
Your Honors, if there are no further questions, I've well exceeded my time, and we would respectfully request that the court affirm the judgment of the district court. Thank you.
Thank you, Ms. Ray. Ms. Hester, you have some time reserved.
Thank you, Judge Gregory. I'd like to make a point about this second issue to start, and that's the government repeatedly calls this a credibility determination by the district court, but actually the finding the district court made was what the body camera footage shows. And that's on page 296 of the joint appendix. And I think that that is significantly different from the court making its determination based on whether it thought the officers were credible or not. My second point with this is, again,
before you go there, I don't want to beat this, but I'm puzzled about this handshake, and that an officer can testify, as Ms. Reyes indicated the record. She pointed out 3 things on the records, and all they said in both instances, it was a long handshake. It was this, in my experience. But at any time, was the handshake ever demonstrated or described?
no.
Or do we just assume everybody knows what a handshake is, and then everybody knows or accepts that an officer can know when a handshake is more than just a mere handshake? I'm trying to understand that. It would seem to me that if you wanted to rely upon a handshake, you would say to the officer, would you demonstrate to us the way the handshake was done? And then once it's done, maybe for the court to describe, Your Honor, he's placed his hands in this manner. There was a manipulation in this manner, and was consistent with someone who was making a transfer. Other than, because I get it, what the Supreme Court and others saying, but even though the courts may say it, you can go with something wrong forever. You can start out and say it because no one has ever asked the question, and you wonder, how is it that a handshake, that an officer can say it was a long handshake? And in various cultures, handshakes, that's why I'm not trying to ascribe anything to these young men. I don't know them. I don't know anything about it, but I do know that young people shake hands very differently than I do. And my generation shakes differently. It's not all the way we do it when we come down to court. It makes me wonder, if we walk down from the bench and shake hands, if I hold your hand a little long, is that indicative of something that would be consistent, that something could have been exchanged? But I'm like, I don't want to make a big deal out of it, but it seems like to me it's a simple thing to just describe the handshake rather than say it was a long handshake or I know what a handshake. You're just saying the word over and over, but you haven't told me yet, what is a handshake? Was it done?
That was not done, and it may be because the detective wasn't able to see their hands, because he never testified either that he could see their hands.
That's a whole different ballgame you just added on this. You're telling me the record indicates that the officer testified he did not actually see the hands?
No, he never testified that he could see the hands, is what I'm saying. So not only did he not describe the handshake, he never even said that he could see their hands.
What did he say?
He just said that he saw a handshake. That's all that he said, that he saw a second handshake.
Well, you have to assume he saw the hands. I mean, if you think the defense counsel does have some duty there to say, if you didn't think he saw, at that point, most people go say, if you saw a handshake, you saw the hands. I'm not following that point.
Mr. Drakeford wasn't represented at the time, Your Honor. He was proceeding pro se. So there was not a great deal of cross-examination.
That was not a good idea on his part then. Yeah.
Perhaps
that doesn't help him here.
But, you know, the officer was there was an entire lot between him and the car stereo warehouse. So whether, you know.
Well, I'll leave it there. Officers, I think he said he had a clear line of sight. I don't want to beat that point. My point has to do with the nature of the handshake that's being so relied upon here based upon the officer's experience. And he does have experience, but he's no better than anybody else when it comes to, you know, describing it. He's got, you know, nearly everybody, that's my point, nearly everybody has seen someone exchange something in their hands in a secretive way, whether it's not drugs or whatever, just money or whatever, you know, for a legal purpose. It's just could be for fun or whatever. Yeah. But that's a common experience. But I'll move on from that.
I think Ms. Hester, I think that just very briefly in terms of with the handshake here, he said, I saw a handshake. And as Judge Wynn says, a handshake is a handshake. Everybody knows what a handshake is. Unlike cases where they said, I saw their hands and looked like they exchanged something. That's not the evidence here. In other words, you could say something, well, I didn't see what they exchanged, but it looked like they exchanged something. Here, it says it was a handshake. That was it.
That's it. And the officer actually did expressly say that he did not see anything change hands. If I could just make one final remark, and that is that I think the danger of attributing this much value to a police officer's experience is that you avoid doing that, you avoid what Glover requires, which is to consider the totality of the circumstances, including all of the information that undermines that reasonable suspicion.
Well, what it means that guilt is determined upon the experience of the officer, not of the conduct of the investigation. But I guess that goes to credibility. I mean, that's again, the court cases are going that way. But you know, it doesn't mean that we don't go back and understand. Wait a minute, what are we saying here? Sometimes we do stuff, we don't figure out what we're saying. And should it be that a new officer comes on cannot convict as get many people convict as someone who's more experienced, and maybe so. I mean, but at least let's recognize that's what we are doing here.
Right, and also recognize the officer's testimony that the reason that people exchange drugs in a handshake is to hide the act. But in doing that, he ignores all of the evidence that these two men had much easier ways to hide their act than by standing and having a public handshake in front of the store because their cars were parked right there.
Wow.
All right. Thank you so much.
Thank you.
Ms. Hester and Ms. Ray, thank you so much for your arguments. Job well done on both sides. You're both excellent attorneys, and you certainly showed that skill and ability here today. And I apologize that we can't come down and shake your hands, but know, please, that we nonetheless appreciate your argument, and we ask and hope and pray that you will be safe and stay well. Thank you.
Thank you, Your Honor.
Thank you, all of you, Your Honors. Thank you.
Thank you.
Ms. Stinson, you may proceed.
Good morning, Your Honors. May it please the court. My name is Kate Stetson. I represent the petitioner in this case, Mountain Valley Pipeline. Pipeline permit applications, as this court knows, require a lot of complex federal and state choreography. Many different federal and state agencies have roles to play in that process. This appeal involves whether the state agency responsible for certifying North Carolina's water quality overstepped its role. A state water quality certification, also called a 401, is a key component of the federal pipeline permitting process. But water quality is also the limit of the state's certification authority in that respect. North Carolina can't issue a water quality certification conditioned on changes to a pipeline's route. That is for FERC to decide. North Carolina can't deny a water quality certification based on its conclusion that the pipeline isn't needed. That's for FERC to decide. And similarly, North Carolina must consider that water quality certification based on the activity that is proposed. And here, that activity is to transport natural gas from point A to point B. If that proposed activity will comply with state water quality standards with certain conditions and mitigation, as is always the case, then certification shall issue. That's the mandatory language of the regulations. The North Carolina DEQ in this case was presented with a detailed report from its hearing officer that the proposed Southgate project, which is at issue here, would not violate state water quality standards if it was carried out under specified conditions and with the best management practices to which Mountain Valley had committed. The DEQ's decision letter, though, which is all of 2 pages, didn't take issue with any of those findings. Instead, the DEQ concluded, and this is at Joint Appendix 1363, that without certainty that a related pipeline project, the mainline project, would be completed, it would deny the Southgate project's request for a water quality certification. And in resting its decision on that basis, the DEQ went outside its lane. And it went outside its lane for 3 reasons. One, based—
I'm sorry, Ms. Stetson, before you get to the 3 reasons why it went outside its lane, I have a jurisdictional question, really. At the end of the denial letter, it says that the petitioner, MVP, can go to the North Carolina Office of Administrative Hearings within 60 days to, I guess, appeal the decision. Did MVP take advantage of that process?
It did, Judge Thacker. It filed an appeal with the Office of Administrative Hearings, and then it also filed a petition for review in this court. Unlike FERC, that process isn't jurisdictional. I think that's probably why North Carolina didn't raise it as such. And right now, the Office of Administrative Hearings proceeding has been held in abeyance pending this court's determination on the petition for review. The 3 reasons I mentioned, and I'll get into each of them in turn, have to do with the DEQ's failure to abide by its own regulations, its failure to stay within its statutory boundaries under the Clean Water Act, and then, of course, just its basic failure under the Administrative Procedure Act to explain.
So this is about North Carolina's regulations, right?
Yes.
Then can you just explain to me a little more about what, especially if it's appealed to the North Carolina Office of Administrative Hearings, and we're talking about North Carolina regulations, why this court has any business at this stage meddling in what North Carolina does before the administrative remedies have been exhausted in North Carolina?
I think, Judge Thacker, the reason has to do with what I mentioned in passing is the difference between this kind of seeking reconsideration from the Office of Administrative Hearings and what would have happened if we had sought rehearing in front of FERC, if FERC had made this decision. You know, FERC's rehearing process is jurisdictional. We can't come to you or to the DC Circuit until we complete that process, nor can any petitioner. This is different. This is an opportunity that is provided to a petitioner under the North Carolina processes, but it's not exclusive and it's not jurisdictional. So we chose both paths, and ultimately, upon agreement with North Carolina, we agreed to hold the administrative review process in abeyance until this case went forward. So in terms of what this court has to rely on, what this court has to rely on is the North Carolina DEQ's determination. That is the permit determination, just like this court reviewed the Maryland 401 certifications in the MVP case, and I think the Southgate case. So, or I think the ACP case, I mean.
Ms. Stetson, then, given your reasoning, which I understand, you made it very clear, this ruling, our ruling, then would not be final, would it? Then North Carolina, since you have a parallel proceeding, could rule differently, correct?
No, I don't believe that's the case. I think the reason that the parties agreed to hold the hearing in abeyance, that additional process in abeyance, was precisely to wait for this court's decision before deciding whether to move forward or not. If this court concludes that the DEQ overstepped its bounds, that the basis for its determination was not an appropriate basis under the North Carolina regulations or the statute or the Administrative Procedure Act, this case would return to the DEQ for further proceedings on that. So I don't think there's a finality issue here. And I'd point out that the DEQ has not raised, agreed with us to obey the other case, and has not raised any jurisdiction or finality issues here.
But doesn't that undermine federalism? The whole idea is allowing the states to monitor their waters, their surface waters, and the barriers and riparian barriers and those kind of rivers. Well, why would we be the final word on what the North Carolina law would say about those things?
I think it doesn't undermine federalism, Judge Gregory, because of the cooperative federalism that's baked into this entire process. I mean, the reason that we're in front of you in the first place is because we are here because of a certification proceeding that was kind of a pertinent to the federal pipeline permitting process. So there already has been that allocation of state authority and federal responsibility, including this court's responsibility to take appeals from denials of, among other things, 401 permits. So I don't think you're overstepping your role at all. I think the DEQ overstepped its role, which is the basis for our appeal. If I could turn to the regulations, and I want to make one thing clear from the beginning, there's a lot of back and forth in the opposition briefs and the reply about what regulations control, the current ones or the former ones. And our point is, under either regulation, under the current regulations or the former regulations, DEQ violated them both. So this court needn't conclude, we suggested that it needn't conclude which regulations apply because the same answer ends up either way. But just to start with the current regulations, and this is 15A of the North Carolina Administrative Code 2H.0506, the current regulations require the DEQ to assess whether the proposed activity, that's the language, has satisfied 6 specific factors. And then upon determining that the proposed activity will comply with state water quality standards, the division shall issue a 401 certification. The hearing officer in this case, and you can find this in detail at Joint Appendix 1349 through about 1355, the hearing officer in this case did a careful and thorough job walking through each of the various water quality issues that are pertinent to this case. There are some that are not, and concluded that with certain conditions attached, that water quality standards would not be impacted by the proposed activity. Where the hearing officer went off the rails and where the DEQ based its entire determination was in finding that because the hearing officer and then the DEQ were not sufficiently certain that the mainline project would be completed, that all of those other findings, that water quality wouldn't be impacted, that surface water wouldn't be impacted, that no mitigation was necessary, that any mitigation under riparian rules was accomplished, all of those things were thrown out the window in favor of this determination that because mainline may or may not go forward, they weren't sufficiently certain about the Southgate project to be able to attest to its water quality. That is a kind of re-examination and negation of the project's purpose that is outside of the DEQ's lane. Under both the current regulations and the former regulations, if we want to talk about those, what the DEQ is asked to do is to look at what the activity that is proposed is planned to do.
So could we find that maybe DEQ properly denied this 401 certification and had jurisdiction under the Clean Water Act. If I'm following where it looks like to me, you really may be going, I'm not sure, is that it wasn't a reasoned decision because the record reflected that there was, it didn't violate the water quality under Section 401 certification. And if your client complied with it, then it would be fine. But yet they denied it. And there seems to be some inconsistency in that determination. Am I following that right?
Yes, Judge Wynn. That is
so
definitely.
When we this is where again I can get confused when we're going to spend time on the Clean Water Act. We don't really need to. If we can say, yeah, they did all right, or a Section 401 certification, it's the decision that ultimately came from those determinations that's important. And it is your contention, as I understand it, that it wasn't a reasoned decision because of this inconsistency.
Judge Wynn, that's right, but I'd want to clarify, if I could, that there are two types of unreasoned decisions. There's a decision that's not accompanied with the right reasoning, and that would result in a kind of, the do-over that we've seen, where you send it back to the agency and the agency supplies the missing reasoning. But the first two of our arguments in our brief are the other type of unreasoned decision, which is more that the decision is outside of the DEQ's authority to make in the first place. If the DEQ based its decision—
But my point is, you don't need to go there, do you? If you can get to that first one, that is that what they ultimately did is inconsistent. You can't say it makes 401, it's a 401 certification, and if you comply, it's there, and then come back and deny it.
I think what we would argue is, yes, to your point, but to the extent the DEQ based its decision on something that it was not permitted to consider, that is, I think, more of a significant defect in the DEQ's decision. It wasn't just that its decision didn't line up with what the hearing officer said throughout his decision. It's that what the DEQ based its decision on, and you can see in North Carolina's brief, it says there is no dispute about the factual basis for the DEQ's decision. That we agree with. The DEQ based its decision on something that it was not permitted to consider. It is not permitted to consider whether the purpose of a project will be ultimately fulfilled. That is in FERC's lane. That is part of the purpose and—
Now, are we talking about the 401 certification?
Yes, that is what we're talking about.
Well, Stetson, I don't read it that they're saying they weren't weighing the purpose. It seems to me when I read it, and I know you disagree with this, but let's get at least the apples to apples. It's not the purpose. They're not saying that if this project goes through North Carolina all the way to where it's supposed to go, to Graham, North Carolina, that its purpose wouldn't be fulfilled. They wouldn't. What they're saying is that how can we do our fiduciary duty to protect our waters and say have the least impact? Because there will be impact here, some temporary, sometimes short-term, whatever, it will be impact. We are trying to say that based on the stoppages and the questions about whether or not this thing is going to get done, we got to determine whether or not should there be any disturbance or impact when it may not happen. But they're not saying that we're weighing the purpose, whether the purpose is good or bad. They're saying whether or not on this stage, is it viable to go forward in doing our fiduciary duty with such a sketchy, if you will, project that may never need to disturb any of North Carolina's waters and surface waters because it's too tenuous. Not that the purpose, they weren't weighing the purpose. Would you respond to that? And you said, I disagree with saying the purpose of the project.
Sure, Chief Judge Gregory, and I know my time is running out, but I hope you'll permit me because there are a couple different responses to your question. The first is, the DEQ certainly did take issue with the purpose because, of course, what it was supposed to look at is what is this proposed activity? What is the purpose of the project? And by saying we know what the purpose is, we just don't think it's actually going to happen, that negates the purpose of the project. And when you said viability, Chief Judge Gregory, I think that brings up a very important point. And I think it's one that the court can rest a lot of confidence in. Because when I talked earlier about this being FERC's job, FERC's decision about purpose and need, I'm referring specifically to a statutory obligation that FERC has. And this is 15 USC 717 FB, as in boy. A certificate shall be issued to any qualified applicant, and then there's words that don't matter, if it is found that the applicant is able and willing properly to do the acts and to perform the service proposed. So that viability question, Chief Judge Gregory, that you just raised, that's the component of FERC's determination that says, is there a need for this project? Can this applicant do this project? And when it comes down to the current viability of the project, the one important point I want to make, and I know I'm over my time, so please indulge me for just this point. What FERC concluded in this case was that work could not go forward on the Southgate project until two things happened. The first is that the necessary federal permits all issued. And the second is that FERC's Office of Energy Projects issued a notice that Southgate could proceed. So there is nothing that is going to happen imminently with Southgate until those two FERC conditions are satisfied. And one of the real defects in the DEQ's order here isn't just that it overstepped its lane, it's that it had that option available to it. It could have mirrored those conditions and said this will not be permitted to go forward until all federal permits are issued and FERC issues a notice to proceed, but it chose not to do that. It chose to question the very purpose of the project and to deny it on that basis. And that, we think, was a statutory and regulatory error. Thank you, Your Honors.
Thank you, Ms. Stetson. Mr. Crabtree.
Morning, Your Honors. May it please the court. My name is Taylor Crabtree and I represent the respondents. The department acted well within its authority in denying MVP's request for a 401 certification for the Southgate project. This case is not about the department substituting its policy preferences for those of the Federal Energy Regulatory Commission. This case is about whether a state can require an applicant to provide reasonable assurance that the water quality impacts of the project it proposes will not be objectively unnecessary. Southgate is atypical in that it is wholly contingent on another large linear project, the main line, that is still under construction. And the main line has been subject to an abnormal degree of regulatory uncertainty, given the multiple verifications and authorizations that have been vacated by this court. Southgate will have its most significant water quality impacts during the period of construction, as streams are dammed and pumped, and trenches are dug through stream beds and wetlands. Allowing that construction to commence without reasonable assurance that the mainline project will ultimately be completed is inconsistent with the avoidance and minimization requirements of North Carolina's 401 rules and its riparian buffer rules.
Mr. Crabtree, could you briefly address the jurisdictional issue that I asked Ms. Stetson about?
Certainly, Your Honor. So I believe jurisdiction for this court is found in the Natural Gas Act at 15 USC section 17R, subsection D1, which provides that the United States Court of Appeals for the circuit in which a facility subject to regulation under the Natural Gas Act is proposed to be constructed shall have original and exclusive jurisdiction over any civil action for the review of an order of a state administrative agency acting pursuant to federal law. That covers section 401 certifications like this one. We've taken the position that this jurisdiction is original and exclusive as the statute provides, and that the Office of Administrative Hearings in North Carolina does not have jurisdiction over this action at all. We think this action lies exclusively in this court, but we did agree to hold that action in the Office of Administrative Hearings in abeyance to avoid having to resolve that issue. But we believe that this action is properly before this court, and it's properly exclusively before this court.
You heard Chief Justice Gregory's question and the exchange on the purpose here. That denial letter that was issued to the petitioner contained a lot of references to the viability of this project's intended purpose, given its reliance on the mainland project. Why is that relevant to determining whether the proposed pipeline satisfies the state's water quality standards?
Certainly, Your Honor. So the state's water quality standards, in order to issue a 401 certification, requires an analysis of whether the project has avoided and minimized water quality impacts. So whether the impacts that occur are necessary. Given the substantial uncertainty surrounding the main line, North Carolina was concerned that any water quality impacts that were incurred by the project prior to achieving certainty regarding whether the main line would be completed would ultimately be unnecessary. So if Southgate were allowed to go forward and the mainline project ultimately did not come to fruition, any water quality impacts, the damming and pumping of streams and cutting of trenches through streams would ultimately be unnecessary. And that's
so now answer, just to help me out, don't you have to assume that the pipeline will achieve its purposes? And so isn't your role here to consider how to minimize the pipeline's impact given its construction?
So, Your Honor, I think this case can be distinguished from cases where MVP accuses the department of reweighing the purpose. But I think Chief Judge Gregory made a good point. This is not reweighing the costs and benefits of the proposed pipeline. This case is not about the department saying that the benefits of the natural gas supplied by this pipeline are not sufficient to outweigh the costs to North Carolina's environment. This case is about North Carolina's water quality standards regulations, which require that the impacts to water quality, and this case this pipeline will have significant water quality impacts, will not be for no purpose at all. And in this regard, we're not second guessing any determinations made by the Federal Energy Regulatory Commission. I don't think the Federal Energy Regulatory Commission could possibly disagree with us that if the main line does not come to fruition, any water quality impacts of this pipeline will have no purpose. They will have been unnecessary.
Let me ask you a question about the ultimate decision and the reasoned decision making here. You had a hearing officer and he found, and I'll quote it, the project is not expected to violate water quality standards if the certification is issued and if the conditions in the 401 water quality for certification are fully complied with by the applicant. So it seems to me, if you did comply with the 401 quality certification, jurisdiction allows under the Clean Water Act, then once you get to this, it says, how does this finding lead to your justification in the denial letter approving this project? It says all of these things about the environmental impacts to water quality and the so-called riparian buffers. I love that word. How does that jive is what I'm saying. It looks like it's inconsistent to me.
Certainly, Your Honor. I think what's important about that statement that you just referenced is that statement was contingent and conditioned upon a certification issued with the conditions that were recommended by the hearing officer. One of those recommended conditions was a condition that required the resolution of all legal ambiguities regarding MVP's permits for the mainline project, those being resolved prior to commencing with construction. And the hearing officer expressly recognized when he recommended that condition that a denial might be necessary to address that same concern, the concern about the uncertainty with whether the main line would ultimately be completed. And so I don't think that can be viewed as inconsistent with the department's ultimate decision when the department ultimately took that second recommended condition, not a recommended condition, the recommended option. The recommended option to deny the permit and then require MVP to reapply once its path forward on the main line is clear. So I'd like to make 3 points today. First, the decision was consistent with North Carolina's 401 certification regulations and its riparian buffer regulations, both of which require an analysis of avoidance and minimization. Second, the decision was within North Carolina's authority under the Clean Water Act. And finally, the department adequately explained the basis for its decision. So starting with consistency with state regulations, absent a certification, the Southgate project will violate water quality standards in the streams and wetlands that it crosses. Now, MVP faults the department for not spending much time on this issue, but there was no need to. It's not contestable. MVP cannot and does not argue that when it dams a stream to allow it to cut a trench through the middle of the channel, that will not deprive aquatic organisms of the ability to use that stretch of the stream during the period of construction. There's no stream for those organisms to use, and that violates North Carolina's water quality standards in 2B0211. Now, North Carolina's...
I go back to the connection between this Southgate project and the main line. What would need to happen for the DEQ to be assured that the main line will be completed?
Well, Your Honor, at a minimum, I think MVP would need to address the issues that led to the denial. So on the second page of the denial at 1363, the department references the multiple permits that had been vacated by this court. At the time the department issued its denial decision, this court had vacated MVP's authorization through to proceed through the Jefferson National Forest. That authorization was reissued a couple weeks ago and was immediately challenged. This court had also vacated the verification of compliance with the Army Corps Nationwide 12 permit issued by the Huntington District Engineer. That was reissued back in the fall, and as you know, Your Honor, this court recently suggested that permit, that reissued authorization, was likely unlawful again. So at a minimum, it would need to address those concerns, address those deficiencies in those permits prior to reapplying to the department. So North Carolina's regulations do provide a path to approving removals of use, to approving such removals of use that would otherwise violate water quality standards. North Carolina's anti-degradation policy, which is another component of its Clean Water Act standards programs, allows for removals of use to be approved, provided that the applicant can show that the project adequately avoids and minimizes water quality impacts. Analysis is required by both the pre and the post June 2020 versions of the 401 rules, and it's also required by the riparian buffer rules. The director reasonably determined that MVP failed to make that showing because the Southgate project is wholly contingent on the main line for viability, and there remains significant critical uncertainty regarding the mainline project's ultimate completion. Now, the department's concerns about the viability of the mainline project were not speculative. As I just mentioned, there are multiple permits and authorizations that have been already vacated by this court, and at the time the department issued its denial decision, the project was also subject to a stop work order issued by FERC based on the need to redo a flawed biological opinion. Given this cloud of uncertainty regarding whether the main line would ever be completed, the department acted in accordance with its regulations in denying the certification because it lacked reasonable assurance that construction of the project would not result in unnecessary water quality impacts.
So it seems to me you and the petitioner have some disagreement as to whether that Jordan Lake riparian buffer rules are part of the state's water quality standards as it relates to this 401 certification. They cite the CPA documents that identifies it for the Clean Water Act, and that seems to be a big disjoint right there. So explain your position a little bit more on that, because I mean, once you get there, if it takes you out of this 401 certification authority to do what you did, if it's under the federal law there.
Sure, Your Honor, happy to address that. So if you look at section 401, subsection D provides two kind of categories of bases that a state can rely on in issuing its 401 certification decision. The first is a set of enumerated Clean Water Act standards programs that includes the state's water quality standards. And the second is other appropriate requirements of state law. North Carolina's argument is that its riparian buffer program falls within this grant of authority for other appropriate requirements of state law. That's because the riparian buffer rules, although they don't fall within that enumerated set of EPA-approved programs, they are plainly focused at preserving water quality. And as we explained in a citation to EPA's handbook on this point, pages 8 and 9 of our brief, EPA has long taken the position that riparian buffer rules like the Jordan rules do fall within this grant of authority for other appropriate requirements of state law. So MVP and the state, Your Honor, may have just been talking past each other a little bit. We have consistently contended that this falls within the grant of authority for other appropriate requirements of state law, not in that the former category of state authority. So turning to the Clean Water Act, the department's decision was not about the department's policy preferences. It was about water quality, and it was about preventing unnecessary water quality impacts. And that falls within the scope of North Carolina's authority under the Clean Water Act. So as we just discussed, there's two regulatory bases for North Carolina's decision, and both are permissible bases for a denial under Section 401. Section 401 allows a state to base its certification decision on either one of several enumerated Clean Water Act standards programs. That includes the state's water quality standards or other appropriate requirements of state law. And as I explained earlier, the project will remove uses in the streams and wetlands that it crosses.
So the answer under the Clean Water Act, am I oversimplifying this by saying that you're simply saying that you denied this certification based on North Carolina's water quality standards or your own quality standards? And,
yes, sir.
And having done so, you didn't act arbitrary or capricious.
Yes, Your Honor.
Is that an oversimplification?
I don't know if I would say it's an oversimplification, but it's certainly a simplification. And I think it's accurate.
I mean, anything else you add to it is nice, but that's really all you're saying, isn't it?
That's correct, Your Honor. This is about North Carolina's water quality standards, and it's about North Carolina's requirement that any violations of the water quality standards can only be excused if the project avoids and minimizes water quality impacts.
So am I assume now you're going to go to your third point? If we agree with you on the 401 certification, we agree on this is clean water, then the question relies upon whether this was a reasoned decision.
Sure, Your Honor.
It goes back to the findings as opposed to your conclusions, where I seem to see there's some inconsistency at the very least, if not just it doesn't follow it so much in terms of what was found and what was concluded. It seems to me to be the heart of what we're dealing with here. I mean, we can get into I don't know what we need to decide. Sometimes you can actually, if we got there and went in that direction, we could assume the first two things and get here. But I'm concerned about that. The findings that were made and what the conclusions, there seem to be some inconsistency. And I know you say it's conditioned. So kind of explain how that condition takes out the inconsistency.
Certainly, Your Honor. I believe the inconsistency you referred to earlier was in the hearing officer's statement that the project will not violate water quality standards if a certification is issued with the recommended conditions.
If it complies with the condition, that's right.
Yes, Your Honor. So I think it's important to remember that one of the recommended conditions that the hearing officer had proposed was to require the MVP to wait to begin construction until all legal ambiguities regarding its permits had been resolved. And I think here it's critical to understand that the hearing officer's proposed condition in this regard is different than the condition that was ultimately adopted by FERC. MVP in its brief repeatedly equates the hearing officer's proposed condition with that proposed by FERC, but this is a significant difference. FERC would have allowed MVP to begin construction, as Ms. Stateson recounted earlier, upon issuance of the permit and a notification from FERC. What the hearing officer would have required is that the legal ambiguities, that any potential challenges regarding those permits to be resolved prior to the issuance of, prior to allowing construction to begin. And that's critical given the number of verifications and authorizations that have been issued by various federal agencies, only to be subsequently vacated by this court. That's happened 2 and soon to be likely 3 times from this court. So I think that difference is critical. And to get back to your question, Your Honor, the reason that's consistent with the ultimate denial decision is that the hearing officer recognized that concern about avoiding and minimizing unnecessary water quality impacts, the concern that stems from the uncertainty regarding the mainline project, could be addressed in one of 2 ways. It could either be addressed through this conditional certification, or it could be addressed through a denial, which is the option the department ultimately chose. Now, the hearing officer didn't recommend one or the other. It didn't list either as a preferred option. It simply listed both of them as options. And so in that regard, I don't think you can say that the ultimate decision was inconsistent with the hearing officer's proposal, given that it ultimately adopted one of the two options recommended by the hearing officer. And to the extent that the court thinks that the agency could have better explained its decision to reject the hearing officer's proposed condition, the reason for that rejection is obvious. A condition that required that legal ambiguities be resolved is not an actionable, enforceable condition. So the option available to the department was to deny the certification.
So is it still the condition that, I think you responded to me earlier when I said what needs to happen. Yeah, I think you still responded that sounded like legal ambiguities need to be resolved, or all these issues with the permits need to be resolved first. Is that right?
Yes, Your Honor, that's correct.
Well,
Let me see if I can address
that put the opponents of the pipeline in a position to, well, anytime a permit is issued, we will immediately, file something against it so that there continues to be legal ambiguity. That seems like a problem.
Certainly, Your Honor. I did mean to suggest that, so let me take a step back. The department's denial decision was based on the continuing uncertainty. My only point regarding the condition not being an actionable condition was that when a condition is inserted into a certification decision, that becomes a part of the federal permit. And folks need to know on the ground what that condition means in order for it to be enforceable. That was my only point regarding that condition not being an enforceable condition, given the vagueness of that condition. And I see that my time has expired. I'm happy to
one last question on that, because I
Sure.
just want to make sure. So the hearing officer required that the pipeline wait until you got these legal ambiguities surrounded be resolved. Why wouldn't that lead you to consider the other option that was offered by the officer? That is that the certification be conditioned.
So I'm sorry, Your Honor.
In other words, could the certification be conditioned upon that factor?
Yes, Your Honor. I think the point I was trying to make is that condition, if it had been imposed, would not be an enforceable one. That it would be too vague to be an enforceable condition, and so a denial was the option that the department chose.
I see.
Thank you, Your Honor. And
go ahead. What did you say?
nothing further, Your Honor. Thank you.
Thank you, Mr. Crabtree. Ms. Stetson, you have some time reserved, but before you start, I want to, because I take blame for this, because I use the term viability, and I could tell from your response that I didn't do a good job of clarifying and perhaps use the wrong word. Let me put it simply this way, and I want you to respond to it. I know you have a lot of time. Is this? Well, I think it's better to say it was this, that the 401 certification was denied by North Carolina under this obligation, as it understood under the Clean Water Act, to minimize the impact. Mm. And in that obligation, the reason why they denied it is because at that point, they were not certain when they issued it that there would not result in unnecessary water quality impact. That's the sole reason. The unnecessary has nothing to do with purpose, policy, or, as I've wrongly said, viability. It is all a simple common sense question. That is this: we don't want you to start constructing this thing, because most of the impact is doing construction, until we know it would be even necessary to do so. There's so many, not just suits, but court rulings and judgments of problems, of stop orders, that we don't want you to do something in North Carolina that may be unnecessary. It is not policy. Is that so? Would you respond to that? Why can't they say that simply? Now, there's another question: is which option they took. But I'm talking, why is that out of their wheelhouse?
Yes.
Not to do that under their obligation under Clean Water Act. I said, we don't want you fiddling around in North Carolina with something that might turn out to be unnecessary. You disturbed our waters for nothing, based on where your project is with the main line. That's what they're saying. Now, would you respond to that?
Certainly, Chief Judge Gregory. And I think it also dovetails with the question that Judge Wynn asked Mr. Crabtree. And I think what's missing from both the NCDEQ's brief and from Mr. Crabtree's presentation is that the brief and Mr. Crabtree's argument reduced the issue down to avoidance and minimization. You see that phrase over and over again in the North Carolina brief from page 3 to page 67, avoidance and minimization. The issue is, and this is why the purpose matters, if you go back to the regulations, and now to be clear, we're talking about the 2019 regulations, but let's sit with them for a minute. What it says is lack of practical alternatives, which is what this whole discussion is turning on, may be shown by demonstrating that, words not necessary, the basic project purpose cannot be practically accomplished in a manner which would avoid or result in less adverse impact to surface waters or wetlands. So the reason I said this gets back to Judge Wynn's question is because whether you look at the new regulations or the old one, you have to assume something important. You have to assume, as Judge Wynn said, that the project will achieve its purpose, not that the purpose won't be achieved because of some third condition, but that the project will achieve its purpose. That's what the avoidance and minimization language is tied to. And I think it's quite telling, frankly, that the North Carolina brief drops that qualifier. It's not just, will this project avoid and minimize impacts? No project would be built if that were the standard. It's, can the purpose of this project be fulfilled in a way that avoids or better minimizes impacts? And what the hearing officer in this case concluded was that the answer to that question was no. There's no other way to fulfill the purpose of this project, is what he said, and minimize impacts any further. The water quality impacts will be minimal. The water quality impacts will not be, surface water and other impacts will not be suffering under this particular project. So that's the first point. The second point I would say is just to be very clear on, Chief Judge Gregory, you made the point that you weren't initially asking about the remedy that was imposed. You were asking about the reasoning, and I hope I've answered that. But with respect to the remedy, I want to make clear what the condition was that we're talking about, because there is a passing reference during the hearing officer's decision to this idea about legal ambiguities surrounding the project. And I think for both the reasons that Mr. Crabtree pointed out and Judge Thacker pointed out, that's not a serviceable standard. A permit, when it is issued from a federal agency or anyone else, has a presumption of regularity. So simply assuming that a permit under challenge is going to meet a particular fate is not the standard. The condition that was actually imposed or suggested by the hearing officer is on Joint Appendix 1360. And it's exactly the same condition that FERC imposed, a condition requiring the lifting of all the stop work orders and acquisition of all necessary permits for the Mountain Valley Pipeline mainline project be acquired before the 401 certification is valid. So that's the condition that we're talking about. And one of the things that you didn't hear Mr. Crabtree explain is why that condition wouldn't suffice. And that is one of the points of our brief. If the DEQ is called upon, as it was here, to exercise its discretion in a particular way, it needs to explain why it exercised its discretion to deny a water quality permit when all of the findings leading up to that point suggested that the permit should be granted. And I want to be clear on this too. It's not that the ultimate conclusion of the DEQ was somehow inconsistent with the hearing officer's finding. The hearing officer lobbed in the same suggestion that the permit just be, that the application just be denied. Every single finding pertinent to the water quality question pointed in favor of Mountain Valley Pipeline. That is the inconsistency we're talking about. The last point I'd make is this. In order for this court to uphold what the DEQ did in this case, it has to conclude three different things. It has to conclude that the DEQ did not violate its own regulations when it examined whether a purpose could be carried out. It has to conclude that it did not overstep its statutory authority, despite the fact that FERC is the one who decides purpose, need, and viability. And it has to conclude that despite all of the hearing officer's factual findings that this project would not impact water quality, that the DEQ's conclusion nevertheless can be upheld. We think for any and all of those reasons, the conclusion should be reversed.
Well, let me make this clear,
Yes.
and I understand your argument, so I'm not going to quibble with that because I respect that that's your view. But let's make sure this. No one ever found that this project wouldn't have an impact. I believe, you correct me please, because you know the record far better than I do. But what they found is that they had, at their proposal for the construction, done as much as they could to minimize the impact, both temporary and short-term. Am I wrong about that?
You are not wrong about that. What I would say is, and I think
No, you don't have a lot of time with that. No, I agree. No. The point is that no one ever said it won't be any. It's just that they've done all they can to minimize. I don't hear North Carolina quibbling with that finding at all. I agree with you. If they were saying, oh no, they're wrong. They could have done this and that and that. We're going to go and we're going to cherry pick that and find. No, what they're saying is, now it's up to us to determine this, but that is this, just common sense. We can't be assured here with some certainty under our obligation to protect our state and clean water that it won't be an unnecessary venture. The venture is fine, the policy, the purpose, and all those things, and minimize it, but it would be absolutely unnecessary even to have the properly minimized impact if you start this Southgate project and you have nothing to hook it up to in the main line. And it's not just people rattling their saber or causing it. These are judgments from the United States Court of Appeals for the Fourth Circuit that have come about, and that we're part of. FERC has a role, the state has a role, and an independent judiciary has a role too. And it has done so. And you have to convince us that it's unreasonable for North Carolina to look at what the state of the judicial rulings are and determine whether or not it would be an unnecessary impact to go forward at this point. But I don't take credit with the trilogy you laid out, but I think that's where this case is. They're not just looking at news reports, they're looking at judgments from this court, which, unless the Supreme Court says otherwise, is the law.
Absolutely. Chief Judge Gregory, sorry. Let me make two quick points. The first is, when you talk about a project being unnecessary, I think the next question that you have to ask yourself is unnecessary because of what? Unnecessary because the DEQ concluded in this case, the mainline project might be completed. It's 80% completed. Maybe it won't get the rest of the 20%. That is the problem, though, with what the DEQ did here. In finding that it was potentially unnecessary, the DEQ went outside its lane, because what the department is supposed to do in the water quality certification is to say, if the project's purpose is fulfilled, like Judge Wynn said, we assume the project's purpose is achieved. If it's achieved, has it avoided and minimized water quality impacts to the extent possible? An agency can always find a project might not be necessary, but that's not this agency's charge under its particular allocation of roles. And I would end with this point. Chief Judge Gregory, you made the point about the prior decisions. Some of them upheld agency action, some of them have found fault with them. When these decisions have found fault with agency actions, it's been because either the agency went outside its assigned role, or didn't explain itself, or didn't adequately do its job. And I think in this case, all of those things are true, and the same situation should hold here, if there are no further questions.
I just one question. Can I ask you a hypothetical?
Certainly.
It's a far-fetched hypothetical, of course. That's why it's hypothetical. But if you had a situation where someone is going to build something widget line or whatever it is going to be, and we find out as a matter of fact that they are undergoing bankruptcy and all the kinds of things that it's just clear that there's a problem with not viability. It just, as a matter of fact, they've almost at this point put it on hold and nobody knows what they're doing in the other state, for example. Mm-hmm. Your position is that as long as FERC has okayed what they're going to do in your state, state X, no matter what going on and what the real practical what's going on in state Y, they can never consider that in terms of whether or not it might be an unnecessary impact. Is that your position?
I think granting that it's a far-fetched hypothetical,
it is.
I would say it's our position that there is another agency with responsibility over what you're talking about. So if you take your example and you talk about bankruptcy, let's put it into the pipeline context. FERC would have the authority and the responsibility to make determinations, including the one that I mentioned earlier. Is this pipeline sponsor, this applicant, ready, willing, and able, able and willing properly to do the acts and to perform the service requested? If the applicant proves itself unable to perform the service requested, that would be FERC's prerogative at that point to say this project is no longer viable. And that's why I think the conditions that were attached here by FERC are so important. And again, Mr. Crabtree didn't refute these. The conditions are all federal permits issue again, and the Office of Energy Projects and FERC issuing notice to proceed to Southgate. Nothing is going to happen until those two things happen. And as Mr. Crabtree pointed out, those things are in the process of occurring, but the permits haven't all issued yet. And the notice to proceed has not issued yet and will not until that point. Now, at the point where those permits issue, then I think you should attach the presumption of regularity I mentioned earlier. It cannot be, as Judge Thacker said, that we wait to see whether anyone challenges a permit to decide whether or not a project is viable. If a federal permit issues, that carries something. It carries a presumption of regularity. So at the point where all permits issue and the notice to proceed goes forward, that is the point where Southgate would start, not before then. And I want to make that very clear.
No, I understand your yes. point. I just bring up to you that it was Congress that put this federalism track here, right? It gave the states the authority. It could have said yes. FERC is final, but it didn't. So everything you said in the hypothetical, somebody else like FERC could jump in, but there's nothing that says that the state can't protect itself, and that is not give up its 401 certification.
Yes.
Dealing with my outlandish hypo, which I gave. But I agree with it. Everything you say is true. But because it was Congress that did this, Congress could have said, FERC, you know everything. You're smart. I don't care what North Carolina says. They can do it. No, it didn't. It said yes. North Carolina can protect that. And until Congress changes that, we'll have to grapple with this. And this is the situation. But it's not one to just say that FERC knows everything. It's because the state can. And the state, under my hypo, the state, you would say, no, you have to certify right now and hope that somebody in Washington will save you. But no, the state of North Carolina perhaps can save itself. Physician, heal thyself. That is what they're saying is we have a stake in whether or not that. Now, I'm not saying whether or not that's what we have to decide, but I just want to get it down to what North Carolina is saying and what they're not saying.
Yes.
That's what their argument is in this case. But I think we've said it long enough. And
Chief Judge Gregory, may I make one
30
response?
seconds, I'll give you that. Yeah,
okay, ahead, thank you. And I think the question is, and this is a lawyerly answer, what does final mean? When it comes to determining water quality impacts, North Carolina's decision is final. When it comes to determining the purpose, the route, the need, the viability, other conditions of the project, FERC's is final. So what the DEQ can't do here is to say, yes, our hearing officer determined and made all these findings of fact that as long as certain mitigation and other conditions are met, that the project will not have other than minimal water quality impacts necessary to serve the purpose of the project. That is the end of the road. That is the water quality determination, and DEQ can't step into FERC's determinations to conclude otherwise. Thank you for your indulgence.
Oh, absolutely. Thank you, Council, Mr. Crabtree. Ms. Stetson, very, very well done. I appreciate your arguments. We wish we could come down and shake your hands. We cannot under the circumstance, but please know that our appreciation is nonetheless, and we thank you so much and pray that you will be safe and stay well. Thank you, counsel.
Thank you very much.
All right. My dear colleagues, would you like to have a break or proceed to our last case? All right, there we go. We're going to persevere. We'll go to our third case. Mr. Miller, are you ready?
I'm trying to get my video working. Yes, Your Honor.
There you go. All right.
Thank you, Your Honor. If it please the court, I'm Marvin Miller for Mr. Davis. This case began when Holly Springs police officer Richardson stopped him for tinted windows on a street in town. The officer got his registration, etc., sat in his patrol car, which is a marked car. He was in uniform and was checking him out on the computer when Officer Billig and Boyd arrived in their marked Ford Explorer, and they were in uniform. They talked. They pulled in behind Richardson, had their emergency lights on. The computer check showed no outstanding warrants. It showed that 20 years ago, he had a possession with intent to distribute cocaine charge, and the year before that, a possession of marijuana charge. After about 3 minutes into the stop, the car takes off. Officer Richardson goes behind it in his Dodge Charger, and Billig and Boyd go behind Richardson in their Explorer. There's a high-speed chase through a neighborhood. It lasts for maybe a minute or two. I think Boyd said it lasted less than 2 minutes, whatever it was. The car ends up going between two houses, parking on the between them, cuts off the engine, gets out, and Davis runs down an embankment to a swampy area with Richardson behind him. Shortly after that, Boyd and Billig show up. And when Richardson is about 7 to 10 yards away from Boyd, he pulls out his service weapon and he says, "Stop right there." Now, Davis, a black man, knows when a officer's got his gun on you and he says, "Stop right there," that's not a quote, but whatever language he used, he stopped. He said, "Now you come back here." And he turned around and he came back. In his hand was the book bag or backpack that he had taken with him out of the car. He came back to where Officer Richardson told him to come. Officer Richardson said, "You dropped the backpack." He dropped it exactly where the officer thought it ought to be and obeyed his order. He's at gunpoint. He says, "You go over there and lay down on your stomach, face down." He laid down exactly where the officer told him to, face down on his stomach. Richardson put handcuffs on him and said he was under arrest because he had been speeding, he had been reckless driving, he had been fleeing the scene, and those were the charges. When Boyd and Billig arrive, they go down to where Richardson is, and Boyd sees that Richardson's standing over Mr. Davis. Everything's fine. He has no concern for officer safety, so he leaves Billig and Richardson. He goes to check the thing that could be a danger to the police. And the danger to the police is whether or not the car has its parking brake engaged or is in park. He checks that, that's okay, he comes back down. When he comes back down to where the officers and Davis are, he sees that Richardson has the book bag in his hand. Now, Richardson said that after he had him down on the ground and handcuffed and everything, that he picked up the bag and looked in it to see whether or not there was a gun or anything in it. Why'd you look for a gun? Well, I looked for a gun because he had a drug conviction 20 years ago. Now, it wasn't a conspiracy.
So let's talk law at this point.
Yes, sir.
Your contention is it didn't have the requisite legal authority to search the backpack.
That's correct.
And I take it you want us to rely on the Gant case. Which...
Yes and no. Yes, plus a little bit, if Your Honor, please. What happens is that after Schimmel, Robinson, and Chadwick, there's Belton. Belton is interpreted too widely by too many courts.
Let's talk law first. I got the facts.
Right, so,
I want to know, what law are you relying upon here? I mean,
Gant and Riley.
We have not gone fully in that direction. We declined to even address it in the Farabee case. And if we go with the holding of Gant, the question is, how limited is that holding in terms of, is it just, it didn't say it was unique to vehicles, or what does it hold? And how is it relevant to you here on this book bag?
I'll say how it's relevant. In Gant, the Supreme Court said that courts have been going too far in allowing searches incident to an arrest under Belton, and they said that's not consistent with what we want, and they talked about Chadwick. When they had the Riley decision some years after Gant, Gant was, I think, in 2008, and Riley was in 2014, the court talked about the search incident to arrest trilogy of cases because that was the issue in Riley. And when they were talking about that, they talked about Chadwick and Gant. Chadwick was a case that was raised by the district court in your decision in Lippman, and you overruled the reliance of the district court on Chadwick in that case by relying on Belton. And that was a case where a man was arrested on a drug sale. They took his shoulder bag. He was at gunpoint, and they searched his shoulder bag. And the decision of this court in Lippman was, okay, you can search the shoulder bag because Belton says so. When Gant came down, it reined in that kind of Belton authorization. And it talked about the case in Chadwick, which Chadwick was interesting because it said that if personality, in that case, there was a trunk, it could be luggage, but personal things which the police have in their control are things which require a warrant to search. And in Lippman and in the related case of Porter, both 1984 from this court, the police had the items, but they had been, before the police had them, on the defendant. So the theory was, if you arrest a defendant, whatever he had in his hand or with him at the time of his arrest, you can search under Belton. Gant says, no, that's not true. And that's not.
So let's be clear. Gant, we got what Gant is. We know what it is, and there've been is an opinion in which the 3rd, 7th, 8th, 9th, and 10th circuits have applied Gant in situations like this, holding the police searches of a passenger compartment incident to an arrest are only reasonable if the arrestee is unsecured, and within reaching distance of the compartment at the time of the search. So the question is, do we extend this to closed objects like this book bag? And because it did not specifically find that its rationale was unique to the vehicle context, as it did in terms of a separate opinion or something of that nature. So is this the same thing here? Are we dealing with a book bag as opposed to a compartment? And is our inquiry then as to whether it should be in an unsecured passenger within reaching distance of it? And then that leads us to the next question. If we do say, okay, he is secured and as you said, he's down in handcuffs, we know that, we're down in, he's got a gun on him, then the question is this a search incident to the arrest exception for this warrant requirement?
Well, this is not a search incident to the arrest exception because of Chadwick, which had been abrogated, as you did in Lippman, by Belton. And Gant says, and Riley says that's no longer the case. And here's the situation. The theory behind all search incidents to an arrest is, one of the things is officer safety. So in Chadwick, when the police took control of the luggage, They had it and the defendant didn't. In this case, when Officer Richardson took control of the bag, he put it at the place where he chose to have it. And it can't be said that he put it in a place that made it dangerous to himself, because no reasonable officer is going to manufacture a dangerous circumstance for themselves. And he didn't. He put it where he thought it was safe. And that was his reasonable.
Did he say he put it where he thought it was safe, or did he testify that the book bag was within the wingspan of the defendant here?
He said, in response to a leading question, was it in his wingspan? He said yes, but the standard under Gant, Chadwick, and related cases is whether or not it's reasonable, and it can't be said that an officer.
Did anybody ask him? Did he say that he put it in a place that he felt was safe, like you just said?
No one asked him that question, but for an officer to have a reason.
So he never said that. It's a reasonable conclusion as your argument.
Well, we know that he had it put where he chose. That's undisputed, because he had the man at gunpoint and he told him where to put it. So if you've got someone at gunpoint, you tell them, put it down right there. It's not reasonable to think that an officer is going to place it when he can place it anywhere he wants.
He said put it down right there, or he said put it down?
He told him where to put it down when he came out of the mud. And he had his gun on him. He said, drop the bag. And he had dropped the bag. Then he said, you go over there and lay down, face down. And then he handcuffed him. It's like in Chadwick. Once the officers had the bag, it was under their control. There was no reason not to get a warrant. Once Officer Richardson had the bag, then there was no reason not to get a warrant. It has to be looked at in common sense terms that an officer, where he has him come out with the bag in his hand, and once he's out of the mud, then the officer decides where and when he wants him to put it down, because he's the man with the gun on Davis. And so that was the officer's decision. And one can't assume that an officer made a decision to make something unsafe for himself. This was like police can't create exigent circumstances and then say, aha, we've created exigent circumstances, so we have an exigent circumstance that justifies our conduct. They can't do that. And there has to be a reasonable belief. Now, there's no reason to believe there's a weapon in the bag, and there's no because there's no weapon to do with anything, and it's a traffic stop. There's no reason to believe that there's evidence of reckless driving, evidence of speeding, evidence of fleeing in the bag, because that's driving behavior. So under those circumstances, you have to look at the practical realities of it, and an officer can't manufacture a situation where he says, I have an exigent circumstance for my safety, which is what a search incident to arrest is all about. You look at the decision, I would say, in Littman in particular, where Chadwick, police have it, they control it, they can put it anywhere they want. Once they do that, they're not allowed to claim, aha, we have an exigent circumstance. And because Belton was used by this court in Littman to overrule Chadwick, and because it's been pulled in by Gant, then it applies in the same circumstances, because it was applied to the bag in Littman, and it would apply to the bag here, because that's how this court addressed the issue. And so Gant would now control. The other thing is that the court in Riley talked about the importance of Chadwick and made distinctions between it and circumstances like Gant. And if you look at the totality of the situation in practical terms, there's a limit to a search incident to arrest. It's not unfettered. Even under Schimmel, you can't go to everything that's in the room where the guy's arrested. If he's arrested behind his desk in his office, on the far side of the office, there's a lateral file cabinet with 3 chairs in front of it. You can't search it because it's not accessible. And so an officer can't put the bag in an accessible place and then say, aha, look what I did. Now I get to search it. He can't create that circumstance when he's got total control because he has the man at gunpoint. that doesn't fit with the way the Supreme Court analyzed the situation in Riley. That was a cell phone, but they were looking at search incident to arrest and officer safety. I think I've gone over my time, and that I'd like to reserve the remainder, if I may, please.
Thank you, Mr. Miller. Mr. Rogers?
Yes, sir.
Mr. Rogers, you're muted, Mr. Rogers. Mr. Rogers, okay. Yes, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. I'm Joshua Rogers and I represent the United States. And the case here is pretty straightforward. It's about a defendant who forfeited his Fourth Amendment rights, and it all comes down to control. He maintained immediate control of his backpack during the arrest, and he relinquished control of his vehicle when fleeing arrest.
How did he maintain control of his backpack during the arrest?
Black letter law in the circuit says that, and this is current, lawful arrest alone authorizes search of a person, area, or container, and we look at geography and temporality. So with geography.
Okay. All right, you're getting ready to tell me about how he maintained control?
Yes, Your Honor. So with geography, what we look at is immediate control. That doesn't mean is it in his hands. It means is it within his ability to get to? So, and that's a fact-intensive inquiry. So the backpack in this case. That's
where my wingspan question came in to Mr. Miller, because the officer did testify that the book bag was within Mr. Davis's wingspan. However, Mr. Davis was also on his stomach and handcuffed. So how could he get to it when he was on his stomach and handcuffed? That severely limits your wingspan, I would think.
It may limit your wingspan, but this court and many other courts, including circuit courts, have stated handcuffs are not fail-safe. Handcuffs has, the Third Circuit has pointed out in Shakir, there are many instances in which officers have died because a defendant, or in this case, or a criminal, managed to break out of handcuffs and kill them. So it's not as if because the handcuffs are on, it's the end of the inquiry. It's looking at the geography of it. It is right next to him. He only has handcuffs on, and the officer's in a situation where he's trying to frisk him at the same time.
So your point is that this individual was not secure at the time. And I want to make sure we have the facts down. He was handcuffed. He was face down on the ground. And the officer, wasn't he holding a gun over him at the time?
I don't believe that's clear from the record. It would be implied from what we see if he said I frisked him. I imagine it's difficult to frisk with one hand, but it's not entirely clear, but he does have a firearm.
I thought it was indicated he had drawn that firearm.
He did draw the firearm, but it's not entirely clear whether he'd put it back in his holster. We do know he's attempting to frisk him.
So we'll have to assume, Mr. Rogers, that he still had it drawn, since there's no evidence. There's evidence that he had it drawn, but no evidence that he had reholstered it, right?
If we assume that, I think that we still would.
It's not assuming it. That's the evidence that it was drawn, and there's no evidence that he holstered it, correct?
Yes, and I would still say that the defendant was in immediate control of the container. And by that, again, it was next to him. He has handcuffs that are not fail-safe, and we have an officer who is trying to multitask in having this defendant who has, as the district court found, driven like a maniac, and has now decided to act peacefully. If we believe the way the defendant's argument is going, it wasn't peaceful. This is a 6-minute window that starts with tinted windows, and the next thing, it's him on the ground with this guy. 6 minutes after barreling through the defendant through these 2 homes in his vehicle. So I think that the way he's casting it as this sort of, it's peaceful, everything is calm now, he just got him on the ground. This is a serious situation in part. The bag itself speaks volumes. The defendant has nearly driven off a cliff. And what does he do at that moment? He grabs the bag. He's got a presence of mind to grab the bag. And even when he turns around after he gets stopped in the mud, he's holding onto that bag. He doesn't let go of the bag. And the officer now has to ask himself, in the midst of all this, what's in the bag? And it's right there. We've got a guy who's only handcuffed. And as the defendant pointed out in his brief, he's a big guy. He's on his hands and his face. And the officer now is trying to frisk him and look in the bag. This was more of an
So
extension.
do we apply Gantt here in our analysis of this, or do we go back to the pre-Gantt situation with the United States versus Kearns?
Well, I think Gantt is actually helpful here. I mean, Gantt more addressed glove compartments, and we do have Fourth Circuit cases and other circuits that have actually addressed more of the backpack scenario. But if we look at Gantt, one thing that's evident there is that the defendant was locked up in the back of the car, the police car. There was no getting to the contraband in that case. So if we apply Gantt, it's only helpful. In fact, if we look at all the cases that have been cited, they're all helpful to this one because none of them are as extreme as this one. This is at the tip of the spear in this case.
So are you saying Gantt extends beyond vehicular searches?
I would say so, Your Honor, but even if it doesn't, there are plenty of circuit court
Well, I want to
cases.
make sure we establish at least your position on that, because that is one avenue which to proceed if we're going with the Gantt. And there are circuits who have held that, and some maybe that did not. But I want to get your point of view in terms of which way are you saying how we should handle Gantt? Should it extend beyond vehicular searches?
I would say that Gantt is parallel. It's up to the court whether it chooses to, adopt Gantt for these purposes. But I would say, regardless, that Gantt, even though it seems like it's more geared toward that context and everything's discussed in the context of a glove compartment box, this is more in line with the cases like Shakir and Cook, Perdomo, that are specifically dealing with a backpack. So I would say that I wouldn't necessarily, depending on what the court means by extend, I think I would find parallels without saying Gantt exactly applies here. But even if it did,
Gantt relies upon the unsecured passenger, a person who's there, and the ability to be able to reach. That's where the wingspan stuff come in. You get in the current, we're dealing back with temporal consideration and geographical considerations. Gantt's a narrow consideration. So you look at this particular individual, which is where you were going, seems to me, and you contend he was not secured in much the same way as the Fairby case. Interesting to me in terms of someone who's handcuffed, face down, potentially with a gun on him, is not secure. And even if he has a gun, it would seem to me, you say he could have rehosted. Why would you unsecure a person? Would you not consider that an individual who has a gun pointed? Well, let me ask, is that secure? Is that sufficient to amount to a secured situation? Individuals handcuffed, face down in an open field. Okay, so we're not dealing with a house situation where you got people all around, you can go alert others. Gun on him, is that secure?
I would say that it is not, and I would say that based on black letter law. And that is simply that we look at geography. Is he?
I want to hear this black letter law. Cite me where that is coming. Just don't have to give any specific, but tell me what you're relying on when you say black letter law.
Currents. And
that is not. Well, that's the whole conundrum you got. Currents is a different case than Gantt. Current relied upon geographical and temporal considerations. Gantt narrowed this, went to the vehicular situation. And you're saying we should extend Gantt to apply beyond the vehicular situation. And when we do, we're now talking about unsecured versus the ability to be able to reach. And here's this individual, we outside of current now, on the Gantt, and here's this individual on the ground, face down, handcuffed. I'm presuming, are the handcuffs behind him or they're behind his back, right? Handcuffed behind his back, gun on him, or at least potentially have a gun. And you say he could have rehosted, but it doesn't seem to make sense if it's secured to put a gun on someone that you would unsecure a person, to do something else. You would keep them secured in that situation. Does that seem to follow?
Well, the thing is, I think when we say, well, does Gantt apply? Does Currents apply? The Fourth Amendment, it's a cornucopia of cases that deal with all these finer points, and the courts have to look at
It
these.
is, but we have to, as we begin to go through that cornucopia of cases, we like to begin to define and make the law a little clearer in terms of situations, so we don't get into these vague areas. And here we have an opportunity to decide, does Gantt apply in the Fourth Circuit as it does in several other circuits? That's the only question I'm asking. And if it does, that gives us an analysis. If you say no, then we fall outside of it, and maybe we get into more of the incident to search type cases, current and others there. So
what I'm trying to say is that Gantt does not exist in a vacuum. The third, seventh, ninth, eighth, this court have actually narrowed down a discussion in terms of Gantt that applies in this, and it's coming together in terms of the law. So no, I wouldn't apply Gantt in a vacuum, but I would apply it in light of the body of law, especially that's developing around containers. And going back to the geographical and the temporal aspects here, with temporality, usually we're looking at had a half hour passed, 10 minutes. This was as substantially contemporaneous as you could get with the arrest. Davis was being arrested as this happened. So when you have the situation where the geography it is within my wingspan and it's happening it's there while I'm getting arrested, it's difficult to see how that doesn't satisfy currents. And then when we read that in the context of all the other circuits, including Fairby, it's difficult to imagine how that doesn't actually fall within the range of something that would be immediate control that's substantially contemporaneous.
Mr. Rogers, the problem you have is that in Fairby, the person was milling around, correct?
Correct.
And we all know what milling around is. He was walking around. This is not that case. See, would you also agree here that the only justification you had for going in the bag would be based on security of the officer, correct?
I would agree that is a legitimate reason.
Well, that's the only reason. Wouldn't that be the only reason under these facts to go in the bag is for the security of the officer? Is that correct?
Yes, Your Honor.
All right. So that being the case, I can't think of anybody more secure. That you're on your stomach, face down, manacled with your both hands behind you. A person is standing over you with a weapon, police officer. I mean, how could you be more secure than that? Now, you're right, he was not in a car like Gantt, but that's better than a car, because I'm telling you, it is impossible to jump up. I mean, you try that, sort of be on your stomach with your hands behind you and jump up before a person with a gun standing over you could shoot you or do whatever. I suppose you could say he could kick the person or something like that, but the bag, if there's any insecurity, the insecurity would be in his body being able to roll or something like that, but to get to the bag before that officer could get to him?
Well, again, I go back to Fairby. Is a great quote from there about handcuffs. And it's the court stated, handcuffs are not fail-safe, and they do not instantly and completely eliminate all risk that the suspect will flee or do the officers harm.
You know why? Because he was milling around there. He was on his feet walking. Sure, if you have someone handcuffed with their handcuffs in front of them and they're walking around, certainly you could go up to a bag and run. You could get into a bag with both hands and shoot somebody. But that's not this case. This man is on his stomach with his handcuffs behind him, with somebody stand over him with a gun.
Well, this harkens to the Robinson case from the Supreme Court, 1973, when it said the decision to search incident to arrest is, quote, necessarily a quick ad hoc judgment and does not require to be broken down in each instance into an analysis of each step of the search. And so I think what we're doing, all of us here in the ivory tower, we're looking down at this officer who has, again, just been in this heart-stopping situation. He has the defendant with a bag. He's frisking the person, and he turns to look and see if there's a weapon. Seemed like the most reasonable thing that he could do in that moment, and not consider like, oh, okay, maybe I'll just take a look in the bag and see, and then I'll handcuff him I mean, he's in a situation where you have someone who's extremely volatile. That's what has been proven by the defendant at this point. The most reasonable thing he can do is to make sure he's no more volatile than he's already appeared to be, and willing to potentially run over teenagers with a car. And that's part of the record, actually.
Mr. Rogers, you're a very good advocate. I'll give you that. But there's no way you can say this is a case of exigency. My goodness, he's handcuffed. He's going to be arrested. Get a warrant to go into the bag. There's no exigency at all. None at all. I mean, for example, if you really believe that the bag was a problem, you stand over him, you could take, and I think that's what Mr. Miller was referencing to, he could have picked the bag up and pushed it further away from him. There's no exigency as to that. You're talking about a situation where it's more likely that he could get to the bag as fast as the other person could. That's not this case. I mean, that's why you have him. He's not going anywhere. As much as he drove, I know you've gone over it before, he drove, but now he's captured. Now he's subdued. And I can't understand why you say he's not secure, but I know you argue that. But there's no exigency. Just take it down there and get a warrant for it and go in it all you want. And there's plenty of time to do it. You agree with that? What would have rushed the officer from doing the process of putting him in the car and then getting a warrant for the bag? Nothing, correct? You agree?
No, I think that we're Monday morning quarterbacking when we didn't play.
I'm not Monday morning quarterbacking. I'm talking about common sense. What would have stopped? Wait a minute. What would have stopped the police officer in these situations from, when they arrest him, take the evidence as they do, and then get a warrant to search the bag? You tell me. I'm not.
The answer is,
I'm not playing quarterback. You tell me. Facts.
We weren't there, and we don't know. We don't know what the defendant was doing with his legs. We don't know how much he was resisting.
Are you really arguing that we weren't there? That we may as well not have convened today then? If you're saying that the hands of an appellate court is shortened because we weren't there.
I think so. I mean, we have a record.
I think you ought to argue the facts. My question is this: what under these facts would have prevented the officer from taking the bag down and getting a warrant?
You know, of course, could he have done that? Certainly. But was he still justified by the analysis that the court has to look at, which is the geography and the temporality of what's happening? When we look at those facts, I mean, yes, there's an alternate theory, but that does of how it could have gone, but that doesn't necessarily mean.
None of those facts and common sense help you.
Under those facts,
None of those facts with common sense help you, because the common sense is he's on the ground, manacle his hand behind him, and the police officer standing over top of him, and other police is around. That's the common sense of the facts, but none of those help you. But go ahead.
Well, you know, frankly, when I first looked at the case, I thought, wow, he's got handcuffs on, until I went to the Shakir case from the Third Circuit and saw the string site of officers who'd actually been killed as a result of the handcuffs not working like they ought to.
See, part of the confusion here is Gant is a United States Supreme Court case, isn't it?
It is.
And so when you go beyond that, you've got the Gant holding, and you told me Gant applies to searches beyond the vehicle. If that's so, then Gant applies here to the book bag. You don't go to the pre-Gant cases that are circuit court cases. Sure, you can find all other kind of analysis here, but Gant analyzed the vehicle in the context of whether the individual was secured and had the ability to reach. That's the wingspan stuff. You get into a confusion when you want to try to, well, Supreme Court said this, but there's some circuit courts that say there's other ways you can do geographical and temporality with it. That's confusing because the Supreme Court didn't use those cases. They did not use a geographical and a temporal argument with regard to the vehicle case. So that's why I asked, and it seems to me the first decision we've got to make, do we apply Gant in a situation beyond the vehicles? If the answer is yes, we apply Gant. We don't go and add to the Supreme Court's opinion in Gant temporal and geographical things from current, which is, I think it was Fourth Circuit case or other cases. We stick with the Supreme Court. But if you say no, it doesn't apply necessarily because it is not that was a vehicular case, then we're back in the geographical. So that's why I asked, which direction are you going in with that? Because I don't think you can pull up every case that's ever dealt with searches from the circuits and add it to a Supreme Court case that's dealt with a situation that would fit here if you say that Supreme Court case applies outside the vehicle. That makes sense?
It does.
Okay.
But we have merging areas of law. There are different streams of Fourth Amendment law. I mean,
sure you do, and I'm not arguing that point with you. No, I agree. They are merging streams, but we are dealing with a Fourth Circuit, a Fourth Amendment type search here. The Supreme Court in this recent case of Gant, somewhat recent, makes this pronouncement in terms of here you've got a vehicle, and here an individual. The question, the inquiry is, can he get to this other area of the vehicle? Is he secured? And is it in reach? The question I asked, well, if that applies, then you got this backpack. Is a backpack, sort of like a vehicle there? And does the same inquiry apply? Is it secured and within reach? If Gant applies, we don't need, as you say, a cornucopia, whatever of cases out there to go and try to deal with every situation of how we used to analyze these things. Because it could have been done. The Supreme Court could have used, I assume, the Fourth Circuit case occurred and says we're going to follow that reasoning, but it chose the Gant analysis. So that helps to make it cleaner, at least from my perspective. We either going to apply Gant or we say, no, that doesn't apply outside the vehicle. Then we spend our time talking in the things you want to talk about. So I'll ask you again, does Gant apply outside of the vehicle search?
It does. And it must be merged with other cases that actually look at containers.
Tell me a case that tells you that. A Supreme Court case on point that deals with a search must be applied to other circuit cases.
Well, I'm more talking about, for example, this court recently looked at Farabee. It's not as if the court said Gant applies or Gant doesn't.
It ducked that Gant. They declined to deal with it in Farabee, didn't it? I mean, didn't we decline to? I thought we declined to do it. Maybe let me double check, but I thought we declined. Yeah, this court in Farabee declined to decide whether the Supreme Court's holding in Gant should apply to objects like backpacks. They didn't reach it, but assumed that it would. So today I'm asking, what if we don't want to decline applying Gant? We want to decide whether it applies in this circuit. That's a key question, and you got to help me. You see where I'm going with this? Because we could do like we're doing in Farabee and just decline. Sometimes a court just doesn't want to deal with an issue. Well, we might want to deal with that. So, and you say we should apply it outside. So you've given us an answer, but once you've given us the answer, now you want us, well, what is we like the little saying, you want that cake and you want to be able to eat it too with some other stuff there. So I think, I'm not sure it follows that way. It seems to me, if you're going to go with Gant, then Gant is going to inform this decision by determining whether this individual was secured, which you argued he's not, which I thought was, again, that was consistent with it. But then you want to go geographical and temporal parts from current, which is pre-Gant.
And my answer to the question is, I'm not going to say that Gant must apply, but it can apply and be examined in the terms of other circuit court cases. I don't think that's
fair. That's a fair statement. But let me just put it this way. What you need to deal with is in the vein, when you say it can apply, if we say it does apply, where do you go there? That's the question. You're exactly right. It can. It could go either way. We could say no or yes. But I'm giving you the scenario. What if we say it does apply?
If it does apply, then we would be successful in that instance as well, because in that case, you have a clearly different scenario. You have a defendant who is definitely entitled to his Fourth Amendment rights, because officers are actually, you'd say in that case, claiming to have some sort of reason they have to check the bag right then.
In what
when
case? You
he's
say
actually-
that case. You say that case. Which one you're talking? You talking about the Gant case or this case? When you
Yes,
say,
Your Honor.
Are you talking about which factual scenario you're talking about?
I'm talking about the fact that you have officers justifying their search
In
to
this
looking
case,
in that bag in Gant, despite the fact that the man is actually locked up in the back of a police car. So in this case, we could definitely distinguish. We don't have somebody who has, at this point, absolutely locked down. This is not somebody who's completely secure. I do understand, Chief Judge, that you disagree, but based on what we believe the law to be, is that he is not completely secure. Unlike
that's a lot clearer to me now. Now you are saying, what you're saying is, again, applies, but he was not secure. And the question is, can we determine on these facts from if we say, yes, he was secure because he had a gun on him, because he was on his stomach, because he was handcuffed in the back. Sometimes it's law, I hate to say it, but sometimes facts lead to conclusions that we can disagree as to what those facts mean. Some people will look at that and says, that looks like it's secure to me. Courts have a way of looking at it, as you said. You could be in the back of a car, you can't, and so you're not secure. And it's interesting. What we're trying to do is be honest and be open and use some common sense in it. Once it's said, it becomes the law, which is interesting. It doesn't just become the law because the court said it. But sometimes you look at it and you shake your head and says, wait a minute, court says that's not secure. Sure looks like it's secure to me. So that's a good point to leave on that. And I think you've clarified me, at least in terms of your position on it. And I think that's consistent with saying Gant can apply, but you say, no, it doesn't apply because he wasn't secure. Okay,
well,
thank you.
But I'm sorry, I just have to confirm, because we're reviewing the district court. Did the district court ever make a finding that he was not secure, or a finding that the backpack was in his immediate control?
The district court did not make that finding because this was not an argument that the defendant made. He made this argument for the first time on appeal. The arguments he made at the district court were that the stop was consensual and he was allowed to leave at that point, and that he lawfully resisted arrest. So there wasn't.
Well, the district court just said, when defendant Howard Davis fled from the traffic stop, Officer Richardson observed him commit a multitude of crimes, including speeding to elude arrest and resisting an officer. Those observations provided probable cause to arrest defendant for those crimes. Okay, fine. And to search his person and items within his immediate control. The arrest and search of the defendant and his backpack were lawful. There's no finding at all of, or maybe there is somewhere else. If there is, show me.
I would look at JA. I'm not sure I've got this. These aren't page numbers, unfortunately. 151. Yes. The last paragraph at the bottom. The court says, once the officer conducts such an arrest, search incident to the arrest, including a search of the person and any containers or other materials, such as a backpack, within his immediate control, fall within the exception to the warrant requirement to the Fourth Amendment. And so I would say that the court—
Right, but the court didn't conclude that the backpack was within his immediate control, nor did the district court conclude that he was not secure. Even what you just read, and I don't see it on JA 151, but I'm sure it's somewhere because you read it. I understand that the court said what the law was, or what the district court deemed the law to be, but in terms of our review of what the court found, I just don't see that the court found that this backpack was within his immediate control, or that he was not secure. And I assume we could conclude, though, from the district court's denial of the motion to suppress and his recitation of that law, that that's what the district court concluded. But I just didn't see it anywhere, and I've taken up enough time.
All right, thank you, Mr.
I got one question I want to ask for leaving, and don't assume anything from that I'm forecasting anything on this, but I do want to know the answer. If we were to find that the search of the backpack was unlawful, what would be the evidence that would give probable cause for the search of the vehicle? Probable cause to believe that a contraband or evidence of crime was located in the vehicle. What evidence are you relying on for that? Now, you got the first part of the question, because I don't want to, I know that makes you uncomfortable for me to go there, but I'm just assume that's the case. Then can we still find there was probable cause to search that vehicle? That's my question.
Absolutely. The defendant abandoned the vehicle. And when someone has abandoned the vehicle,
wait, you a minute ago, you just faulted opposing counsel for not making an argument below. You didn't make this argument below, did you? This came in a J letter that opposing counsel was correct, was not an appropriate use of a Rule 28J letter, because you didn't cite any new cases, you cited a new argument. Is there somewhere that you argued this abandonment of vehicle below?
There is not.
Okay. But
anything beyond the abandonment argument then? Because if we hold to that, that would follow what Judge Thacker said. But there are facts that would support the probable cause to search this vehicle beyond the backpack.
Then the question in that case is, was it reasonable to think evidence was in the vehicle? And the answer to that would be yes. Without going through the entire 6-minute debacle, the defendant showed many signs that there was something worth looking at in the car. When we saw that there were convictions for, there were drug convictions, it appeared that he was perhaps under supervision. He was definitely on a watch list, and he barreled through an area to get away from the officers and maintains this backpack. Let's assume they didn't look in there, but he maintains this backpack that he won't let go of at this point. I would say on that point, the officers, it was reasonable to think that there was relevant evidence in there. And if there are no further questions, I would just ask the court to affirm the district court.
Thank you, Mr. Rogers. Appreciate it. Mr. Miller, you have some time reserved.
Thank you. If the court, please.
Mr. Miller,
yes,
before
sir.
you begin, I want you to answer that last question for me, because we've gone round and around, but I want you to answer that question. And that is, if we were to agree that the search of the backpack was unlawful, why is it not that the evidence of past drug activity and fleeing from a traffic stop are not enough to support probable cause to believe that there was drug contraband in that car?
A couple of reasons, if Your Honor, please. First of all, the arrest was for traffic violations, speeding to elude, and fleeing. A 20-year-old possession with intent to distribute drug case does not create probable cause or even reasonable suspicion to think that the person has drugs on them at the time. The possession of marijuana, which was 21 years old, doesn't do that either. So
you're saying is the age of the drug charges, okay, but it's some past drug activity. Couple that with, but you're saying because you did flee the traffic stop. I mean, that shows something is there.
That's true.
There's some reason you're doing it, but you're saying that's too tenuous and not connected temporally enough to allow for probable cause to be found.
There's another factor with that prior charge. It's not a conspiracy charge where he's part of a group that is involved in dealing drugs over a period of time.
Don't confuse me. I don't want to go there. I know it's not a conspiracy charge.
No,
I just want to deal with these facts here that are on the table. The past drug activity, and your criticism there is that it's too old. It's a long time ago. And old convictions with fleeing wouldn't be the same if you had some new ones with the fleeing. That would give you probable cause more likely.
That's
is that
correct.
your argument?
There are two parts to the argument. One is the age, and two is the type of charge. because it's a single individual in possession of drugs in a traffic stop 20 years ago doesn't mean that they were part of anything that would be ongoing now. So it's the type of charge and the age in combination don't give any reasonable basis.
And I guess I want you to move on to the next point, because I think I got your point. You stopped for tinted windows. That has nothing to do with drugs. There's no indication he got drugs up there, but he's got these, the way you get the drugs is the old convictions. Then he runs, and you can be running for any reason, but it's I don't know, but you can move to the next. I think I've got your answer on that.
He told Officer Richardson as he's coming out at gunpoint, "I'm sorry, I apologize, I panicked, I just panicked," and he ran. And there are people who jackrabbit for no reason. You find it in DWI cases.
So let me move to the other point, because you're going to lose some time in a minute. If we take Gant and say, okay, Gant applies outside the search, the big contention on from the government's perspective is he's not secure. What makes him secure? And we've been round and round on that, and it may just ultimately come down, somebody got to make a call as to whether as a matter of law that's secure or not. But other than the fact that he's handcuffed, he's face down, potentially has a gun drawn on him, and there have been instances, even with the cases in which he's standing outside handcuffed and he can run back in the house. That sounds like it's kind of tenuous to me, but they are there. And he's pointed to facts in the Gant case in terms of what's secure and what's not. What makes this a really case we can say as a matter of law, he's secure?
Well, you have to look at the officer's actions, because actions speak louder than words. When Boyd and Velick, cause at 209 of the joint appendix, Boyd says he and Velick ran together to where Richardson had Davis. He says that Davis was down on the ground, on his stomach, face down, handcuffed. Officer Boyd saw that situation, and in his police professional training, he was secure, because he was, as he said, standing over him, and you don't holster your gun until you're safe. So, well,
that gives us something to kind of go along. We're not going to say that because the officer thought that he wasn't the guy securing him. It was the other. The other one.
But Officer Boyd took action to protect officer safety. And the action that he took to protect officer safety wasn't to go down and be another guy on Richardson. It was to go check the car, because his first duty is officer safety. The other thing is that Officer Richardson, who has a duty to officer safety to himself, decided where the bag was going to be put and put it there. And he had the man under control. You cannot jump up face down on the ground. If you weigh 235 pounds, you're only 5'11", and you're pudgy as he appears in his photographs.
This is where the law sort of gets into a point where you begin to wonder who makes these laws, because what all this means is if he had come out of that swamp and chunked that bag way from him, we wouldn't be having this discussion right now, would we? Because he can't get to it. I mean, it almost makes the law absurd, that someone who throws a bag can get a benefit. But if you just, instead of throwing something, just drop it beside it, it's a different result that can happen.
There's a difference here. And the difference here is...
But that is true, what I just said, right?
Yes, that is true. And in this case, the distinction from that hypothetical is that he didn't just drop it. When he's told, you stop right there at gunpoint, and he doesn't want to get shot, and he turns around and he does exactly what he's told by the man who's got the loaded gun on him. And he comes out, and then when the man with the loaded gun says, okay, now drop the bag. Yes,
you know what you don't argue here that would be interesting is why would you have said, he had that bag the whole time. He never went into it. He could have gone into it many times, but once he dropped the bag, he had no intention to go into the bag. I mean, I haven't heard you say that, but why doesn't that make sense? That someone, it's not like you getting out of the car and then all of a sudden you decide I'm gonna turn the car loose. The car's there. But if you're gonna apply Gant, he has that bag the whole time he's running. He's in the swamp with it. He comes out with it. If there is something in that bag he wants to access for safety, most people would do it before the police get there. and not waiting to drop it on the side and then try to reach for it. That doesn't seem to make any sense at all.
You're correct. He didn't go into the bag. There are cases where they don't reach this August court where somebody's running and they pull a gun out of their waistband and or out of a bag and turn around and try and shoot at the police, and then the police get them. Sometimes officers get wounded.
I think it's just absurd. I think the whole law here there's a lot of absurdities, but the aim is all the same. And maybe we can make rules that should make sense. And make them, maybe there's a common sense situation here, but the court has gotten us into this whole business of Gantt. We've gotten into the current cases of temporal, and we're trying to look at all the factors involved. And maybe, I don't know. I got a feeling one day the Supreme Court is going to put us in much more of what Mr. Rogers has called that black letter law. I think that black letter law is going to come one day and probably take us out of these scenarios. But you got it. This is a conundrum we're in. So I'm good with my questions. If others might want to go.
May I wrap this with one final piece, if the court please?
Yes, you may.
Thank you. And that is that the idea is safety. If the idea is safety, then police don't create unsafe situations for themselves. They don't manufacture exigent circumstances. Either the law doesn't allow that. And when an officer sees another officer and they're going there to make sure everything's okay and they see things are safe, then they do what their job requires them to do to keep the police safe. In this case, it was go back and check the car, and there, instead of 3 officers, there were 2. The whole principle behind all of this law is that there has to be reason and fairness, and that warrants are preferred. And you have to look at what the police did. They did what their training taught them to do so that they were safe, and they had no legitimate concern about the bag. They had no factual basis for it. It's not Farabee running around loose, destroying evidence, and just doing what he feels like. Here's a man that's immobile at gunpoint. There end up being 3 officers, and the bag is where the officers think it's safe to be. So under those circumstances, since you applied Gantt to non-vehicle cases and Porter and Littman, you can apply it here. It's consistent with your work. Final piece is Shakir, Third Circuit case cited in Farabee, talks about the case of, was it Cursor, I think it is, being one where this court, as many others, had used Belton to go beyond what would be reasonable. And just because he had it at one time doesn't mean that they can stretch that personality without a warrant. I think Chadwick makes that clear. Thank you very much. I appreciate your time and your courtesy.
Thank you, Mr. Miller. Thank you, Mr. Rogers, for your argument. Appreciate it very much. Thank you. Can't come down and shake your hand, but know that we appreciate very much your argument and wish and pray that you'll be safe and well. Thank you,
Your Honor.
With that, I'll ask the clerk to adjourn the court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Amen.